I got the keys.
Okay, ZBA, we are live. We are recording. Phone lines are open. Go for it.
Thank you, Matt, and welcome everyone to the Town of East Hampton Zoning Board of Appeals meeting for May 14th, 2024. We have one canceled public hearing this evening. That is Kevin Sullivan, applicant at 165 South Edgemere in Montauk, Suffolk, tax map number 300-27-3-17.3. Our first public hearing this evening.
Before you go, may I just say I'm recusing myself from this application. So
Thank you. Member Mehring is recusing herself. So our first application this evening is Jeffrey L. Bragman, 22 Shore Road, Amagansett, Suffolk, tax map number 300-131-8-7. The size and location is 48,327 square feet at 22 Shore Road, Montauk on the Sea, Section A, map 2438 in Amagansett. The description: an appeal of the building inspector's determination dated January 18th, 2024 concerning 102-8 of the Town Code. Relief sought, 225-8-50A, an appeal of the building inspector's determination dated January 18, 2024 concerning 102-8 of the Town Code. Appellant seeks to challenge the building inspector's issuance of a building permit that the residence as approved does not comply with FEMA construction regulations and the residential code of New York State. The zoning district is B Residence VE, velocity flood zone, and the secret class is type 2. Council, do we have proper affidavit of service and posting?
1 second. Viewed it, but let me review the hard copy. Yes, we have an affidavit of service that appears to be in order. The board has jurisdiction over this application. No posting was required on this.
Okay, I think we do have a, Tyler, do you have the photos?
Nothing that I've received. I have photos from the last time it was in front of
Okay, no, I think,
Ariel.
all right, did you visited, I mean, I visited the site, I saw that it was posted.
Wait, I'm sorry. Did I get the wrong hearing? What hearing are we doing?
22 Shore Road.
Oh, okay.
Yeah.
Yeah, never mind.
So anyway, I think we can skip that. This is an aerial view of it.
Appeals.
Off the bat, I'm going to talk to Council Bragman and Council Sandleski. We have an objection. There was an addendum to the original application filed by Mr. Bragman. And we have an objection to that by Mr. Sandleski. I would like to hear some arguments from both sides, whether the objection has to do with the timeliness of the addendum number 2 only. So I think I'd like to hear, the board would like to hear some arguments, 3 to 5 minutes max, on both sides, on whether there's a timely matter. So who wants to go? Mr. Bragman, you want to?
I heard the objection.
Okay, it's on file. Mike, Mr.
Good evening, Mr. Chairman, members of the board. Michael Selensky, 860 Montauk Highway, Watermill, New York, 11976. So the current owner of the property, 22 Shore Road, LLC. The objection I raised in the letter to the board deals with the timeliness of the second addendum. That second addendum was received in the office and stamped received by the secretary for the board in early May. I believe it was May 2nd. The town code requires any appeal from a building department determination to be made within 60 days of the application being filed in the building department official files. Obviously, the application that's before us that was filed by Mr. Bragman on behalf of his clients, whoever they may be, because they're not disclosed, was filed in February in a timely manner to the issuance of the building permit. However, he then seeks to bolster and amend that argument in the second addendum, which is filed in May, clearly well after the 60-day time limit to raise an objection. You should treat that addendum as being not properly before this board and pay it no heed, as that 60-day time frame should be treated as a statute of limitations upon which further arguments should not be raised as to the building department's determination. You don't get 3 bites at the apple. You don't get to blow the statute of limitations on a ZBA challenge and then get to challenge the building department's determination and then think of something else later on and get to challenge that as well. So anything that was filed to amend and expand the scope of the challenge to the building department determination that was done outside those 60 days should be treated as a nullity and void pursuant to the proper provisions of the East Hampton Town Code, which requires that they be filed within 60 days. Thank you.
Thank you. Mr. Bragman?
Good evening, Jeff Bragman. First of all, just a point of order. This application is not my application. I'm the attorney. My client is the White Sands Motel Holding Corporation that was submitted to the zoning board with the application, and I tried to correct them when I saw the public notice was in my name. So I would like that noted for the record that the applicant here is White Sands Motel Holding Corporation. The appeal that we filed in February and the brief explanation that we filed 10 or 12 days ago are substantially the same. The argument in this case deals with omissions and contradictions between what's being built and what was presented to the zoning board, and contradictions between what was presented to the zoning board and structural plans presented to the building inspector. And that argument hasn't changed. It's the same, and that's what we intend to present to you tonight. We're going to highlight those contradictions and omissions and make some suggestions about what they mean under the flood hazard district overlay requirements. So I would move that we go forward with it. The amendment that we put in actually was just, it wasn't a fact. It didn't introduce any new facts. It was an attempt to, I guess, summarize that position, but it hasn't changed from the start. We're dealing with 2 sets of plans and the facts on the ground, and that's what we want to present to the board today.
Okay, thank you. We'll make a decision in our discussions, but it's your case this evening, so you might as well.
Yeah. Okay. Thank you. Let me hand out some exhibits here. Good evening, board members. My name is Jeff Bragman, and I represent the White Sands Motel Holding Corporation. This appeal is different from your usual involvement with appeals. I know the zoning board hears often about appeals that are taken from your decisions that go to court. An appeal that is made to your board is a little bit different in terms of the burden of proof and the rules of procedure. Essentially, when you appeal the action of an administrative agent, your hearing is a do-over. It's a completely new hearing. The lawyers, to make it fancy, call it a de novo hearing, which probably sounds like what it means, which is it's a new hearing. And in this case, when you appeal what the building inspector has done, your obligation is to put yourself in the shoes of the building inspector and to make any decision that you think ought to have been made in the first place. So it's unlike an appeal from the zoning board where there's deference to the local board, and the only way to overturn it is if you show a very high standard of proof, which is arbitrary and capricious behavior. That's why in appeals from the zoning board to the courts often say, well, we can't substitute our judgment. We're going to, we're relying on the expertise of the local board unless you show us that it's completely unsupported by substantial evidence. Not the case in what we're doing today. Here, you do precisely that. You substitute your judgment and you make the decision that you think should have been made in the first place. The other thing I wanted to talk about is the fact that the flood hazard district review is an entirely separate and additional review process that occurs usually after a board has made a decision. And I know many of us are more familiar with what goes on in the zoning board than what goes on afterwards with the building department. But it's the building inspector that manages the flood hazard district review, and it's a completely separate and independent review. And the requirements are basically oriented to the policies of the hazard overlay district, which are public safety. I mean, when you're talking about flood hazard regulations, you're talking about life, health, and safety. And the purposes are very specific. They're to protect vulnerable areas from the time of initial construction. They're also to control, these are explicit policies that are announced in the law. They are to control altering natural barriers which accommodate floodwaters. So they don't want to see that done. They also are designed to control the fill and grade in any way that would increase erosion, and they're also designed to regulate barriers, and this is important in this matter, to regulate barriers which unnaturally divert flood waters and increase flood hazards. And of course, the goal is to protect life and health and safety, but it's also to assure that the person who gets the permit assumes responsibility for his or her actions. And it's a law that the drafters have reminded us is very important to follow strictly, because there's a language in the flood hazard overlay district law that says that whenever a requirement whenever a requirement, a statute, a procedure, a policy is at variance from the requirements of the flood hazard overlay district, the most restrictive requirement or the highest standard is meant to apply. And that's because, again, it's a life, health, and safety statute. And I would suggest that when you dealt with a natural resources special permit when the case was in front of you, and comparatively, the flood hazard overlay district is much more rigorous. It's got many more requirements. It's got literally pages of construction standards. It's got enunciated policies that are far more detailed than anything you were dealing with in a natural resources special permit, which might come as somewhat of a surprise. One of the construction standards is that in high coastal hazard areas, which this property is in, a VE zone, man-made alterations of sand dunes, which would increase the risk of potential flooding and damage, are prohibited. They're prohibited. It's very relevant in this case because we were dealing with a very tall dune. That's what the whole the whole controversy or concern, I should say concern, was about in the case. And as I said, literally there are pages of detailed standards, foundations, pile design, pile foundations, concrete strength, bracing, connectors and fasteners. I could go on for longer than that. Some of the standards also deal with breakaway walls and breakaway structures, which were relevant in this case, because there was discussion that this room that was going to be created under the house was going to be constructed with breakaway walls and breakaway structures. And just to emphasize that the flood hazard district rules are more strict than even the natural resources rules, the variance standards, if an applicant wants to vary the floodplain hazard standards, he can come to the zoning board and ask, but the standards are higher here than for an ordinary variance. In fact, it includes that the applicant has to demonstrate that the failure to grant a variance will result in exceptional hardship. So in other words, the law is written to be very strictly construed because it deals with life, health, and safety. So there's a difference between what you look at in the zoning board when you're looking at a natural resources special permit or even variances from a natural resource special permit, and what you look at, what the building inspector looks at when he's looking at flood hazard district permit requirements. Generally, the plans that you see are architectural plans, and they don't have, as I think Chairman Delaney knows from his experience in the building business, architectural plans don't always have the detail that the structural plans have, although they're supposed to be consistent, and they should at least give you an idea of what's going on. But the flood hazard submission, which is managed by the building inspector, who is the local administrator of that code, he gets to see the structural plans. They're the different plans. And as I said, the two should be consistent. They should be cohesive. And obviously, when the zoning board looks at a natural resources special permit case, you want to know what's going on in the building, and the architectural plans are supposed to give you a general idea of what's going on in the building. I want to just take a look at the exhibits. The first one you can skip over. It's the survey. I just gave it to you so you'd know east from west. The second one is the architectural plan, and they're labeled A301, and they show two elevations of the house. You may remember this. The first one at the top is looking at it from the west, and the second one is looking at it. It's looking at the western wall, the wall that's facing the west, and the bottom one is looking at the wall facing the east. And I've brought with me today two experts to give you a more detailed discussion about the plans, inconsistencies, omissions. Kevin Paul's a certified flood. He's a certified flood person. He'll tell you what the actual title is. And Dan Aiello is a structural engineer. A floodplain manager is what he's called. And what's striking about the first elevation is that it basically it doesn't show anything other than the side of the house. And if just looking at it, as someone reading the drawing, not an expert, it looks like there's going to be a pool that's elevated and an area that's going to be occupied by fill, and it's adjacent to that room that they're going to create below grade, and there looks to be other fill on the other side of it, and there's no other structure, nothing else really revealed there that would excite any great deal of attention. And the same is true of the elevation from the east side. It pretty much just shows you the side of the building and it appears to indicate sand or other fill that's occupying the spaces below where the house is elevated on pilings.
I don't see the word fill.
There is no indication here about whether it's fill or what it is, but it looks to be sand or dune, or it looks to be like it's,
There's a difference between whether something's grade or fill, which means something's imported to the site.
no, I mean,
That's the definition.
I'm referring, as a layman, you'll have to forgive me. I was basically saying, it looks like it's sand or dirt. I assume it's sand from the site. There was mention in the construction protocol that when they excavated, they would save that and put it back in. So if that makes it,
Safe to say we can call it final grade.
whatever it is. I'm speaking as a bit of a layman on this. I know how to look at a picture, but I don't always know the construction terminology. So I'll take your expertise on that. The second exhibit that I've given you is an excerpt from the construction protocol that was given to you at the zoning board. And you may remember.
Hold on. Can I ask you, your cover page to that A301 says no natural grade yellow highlighted. What are you referring to?
On which page?
Your cover page here says Exhibit B. It says no natural grade yellow highlighted.
Oh.
What are you referring to?
Oh, yeah, it's a real tiny, it's a very tiny.
I see the
It's
yellow.
a tiny yellow. But it's not really part of my discussion here. That's what they identified as natural grade. They took natural grade from a measurement down by mean high water, and it's repeated on here. But the point of this drawing is just what the drawing shows, not the yellow highlight. Sorry about that. The next exhibit was the construction. This is an excerpt from the construction protocol that was given to you on the night of the presentation. And it has two areas that are yellow highlighted. And basically, it gives a little bit more information about how they were going to undertake the construction. And you may recall that the architect, who I know is here tonight, basically said that they were going to carve out a horseshoe-shaped cut in the dune. They were going to install lagging wall, and then, and I'm paraphrasing, but you can go back to the meeting if you think I've misstated something he said, and then we'll try to do that as close to the edge of the construction as we can get. And once that's up, it's basically pretty typical construction. We are going to build up some structures to raise the pool and raise the house, and then we're going to backfill it. That's what he said. And when you look at the construction protocol on item 17, it indicates that the lagging wall was going to be removed. The lagging wall, for your information, I had to look it up, is the wood, the horizontal wood. They put in pilings they call soldier pilings because they stand at attention, and then they fill them in with lagging wood, which distributes, as I understand it, the load horizontally. So it's called a lagging wall. So this construction protocol says we're going to remove the lagging wall, and the architect said then we're going to, again, I don't know if this is the technical word, we're going to fill the space. I assumed it was with material they had excavated, they're going to put it back in. And he said also that they were going to, everything below there was going to be breakaway structures, concrete was going to be breakaway structure, because what the other comment in the construction protocol was that they were going to excavate down to the level where they were going to put the concrete mat at the natural grade, basically. And he said, when we create that room that they wanted to create, everything's going to be breakaway. Breakaway walls, breakaway concrete, everything's going to break away. So what I want to do now is take you to Exhibit D. This is the structural plan. This went to the building inspector as the local administrator of the code. And this is the document that actually tells you and shows you a little bit more about what they were going to do. And as you can see, you get the idea of this. It's an aerial view, and it's got kind of a wedge shape. That's where they made the cut in the dune. And the length of this, the point and the two legs coming off of it are that lagging wall. And this lagging wall is pretty big. It's a pretty big structure. It's probably 15 or 16 feet tall. It's a big, and I have photos if I can find them for you, but I don't know if I can find them handily. Yeah, okay. I'm going to hand this up. Excuse you. The photo that I just gave you is a little bit of an indication of the scale of this wall, because you can see there's like a front loader in the front. There's some distance, but the wall looks to be about 15 or 16 feet tall. And the second diagram in the same exhibit, if you flip the page, shows you the relationship between the proposed pool and the wall. Now, what you may notice is different here is what I've yellow highlighted, and that is that the notes now say that the lagging wall is permanent. Not temporary, it's permanent. That's a pretty big change from what you were told when you looked at it as a zoning board. But that's what was given to the building inspector. The construction protocol said that it was to be removed. The architect said it was going to be backfilled with sand, and now it's a permanent wall. And in effect, what it is it's a seawall. They're effectively building an armored wall around the house, and it's going to extend as shown on these structural plans. And the wings of it, the reason I showed you the first elevation is because the wings of this extend against the elevations that I showed you. But when you saw the architectural plans, you didn't see any of this. You weren't, the board was not aware of the structure that was going to go in there. We think that's a significant change, particularly in reference to the purposes that I alluded to when I first started talking, that the purposes of the flood hazard overlay district regulations are to control altering natural barriers which accommodate floodwaters. Now, I've seen a lot of cases where people are building near dunes where they pound sheet metal in and it holds the dune back. Then they do the work and they remove the sheet metal and then the sand is filled in. That's not what's going on here. This is a permanent, large 15, 16 foot wall that wraps around this house. And the flood hazard district overlay requirements refer also to the comprehensive plan. And I think one thing that people in East Hampton know pretty well is that we're against shore hardening or any kind of hard structures that are subject to wind and wave action. Because we understand that when you build something like that, it increases erosion and it causes scouring. And also, one of the purposes that I cited earlier was to control filling and grading that increases erosion and to regulate barriers which unnaturally divert floodwaters and increase flood hazards. And that's what this wall is going to do. It's a more subtle wall because it's built closer to the house, but it's a seawall. It's an armored wall. And the other policy and construction standard, specific construction standard in flood hazard district overlay requirements is that in coastal high hazard areas, V zones, which this is, the man-made alteration of sand dunes which would increase the risk of potential flood damage is prohibited. And what you have here, and I'm going to let the experts talk to you more about it, is a dramatic alteration of the dune in an obvious way that's going to increase the risk of flooding and decrease its capability to do what it does best, which is to absorb floodwaters, because you're pulling out the front half of this dune and you're replacing it with a wraparound wall 15, 16 feet high. Now, they're talking about maybe cutting it down like below grade, but the wall is still going to be there because it's got to be elevated high enough to protect the house. This is a VE 17 district. So you're talking about a big wall here. And if you go down to the site, you'll see it's pretty impressive. It looks somewhat like what they use to shore up roads on highways. When highways go through elevations, you see these lagging walls. And then I also gave you a 3D image in the same exhibit. I gave you a 3D image, which shows how that wall is going to be constructed. The first image is just, showing up to the first floor, basically. And then if you flip the page, it shows, the higher area. But you can see that the wall, especially on the second 3D image, the wall extends across that elevation that I showed you in the beginning when I began to speak. You can see it there. But you didn't see it in the architectural plans. Now, there's some other problems here, and they have to do with the breakaway walls, which we understand, and the concrete flooring that's supposed to be breakaway. But that's getting a little into the nitty-gritty and the more technical construction details. So I'm gonna hand that over to the experts. As I said, Kevin Paul, who's the flood management person, and Dan Ayala, who's a structural engineer, and they can take you through the more technical aspects of the differences between what you saw and what we're getting. And then I want to reserve a little time to come back and just chat for a couple minutes. So we can start with, I guess, Kevin.
Announce yourself, who you're with, and your address.
Certainly. My name is Kevin Paul, I'm a registered architect and a certified floodplain manager, H2M Architects and Engineers, 538 Broad Hollow Road, Melville, New York, 11747.
Okay, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, before I introduce Dan, who is a structural engineer, I just want to, a little bit of background.
Chairman, I must object at this point. Does the gentleman from H2M have a waiver from the town board to appear in front of this? As far as I know, H2M is a consultant to the town, and pursuant to the town ethics code, it would require a waiver to appear in front of this board. Does the gentleman at the microphone have a waiver to appear in front of this board?
These gentlemen work for H2M. They have nothing to do with the area of consultation that H2M is involved with in the town. They're advising the town on the senior center, on traffic and parking. They're in separate departments. They don't deal with them, and we can submit paperwork on this afterwards. There's no conflict here. It's like the same thing with attorneys. If there is a separation between professionals in a larger organization and they don't deal with any of the administrative details or the substance of what the other representation is, there's no conflict. They're licensed professionals just like attorneys. So we can deal with that, and I can give you paper on that if and when it becomes an issue.
Just note my objection.
Thank you. We note your objection.
Thank you. Anyway, in working with Mr. Bragman and reviewing the structural plans and the architectural plans, but I identified a couple of issues. And once again, from an architecture standpoint, what a lovely building. I understand you got an award from Peconic AA. Congratulations. Our concern really has to do with flood mitigation and the effect that not only this retaining wall has on the dune, but basically the idea that there's an enclosed space below the structure. Now, if you look at the building code, you're allowed to have an enclosed space below a structure in the VE 17 zone as long as one of the sides is open to grade. Okay, then it's known as storage below the BFE. And if that's the case, then the balance of the walls that surround the structure have to be breakaway. And the reason for that is because FEMA and the New York State Building Code want water to flow under the house, not around the house. Okay, and the reason for that is because if this water is diverted around the house, it's going to create additional damage to adjacent properties. It's harder to control, and we know what happens when you place immovable objects like retaining walls, column piers, and piles without giving it the capacity to flow through. And the easiest way I can explain this is if you guys, I know you all go to the beach. If you stand at the beach, right at the shore, at the edge in your bare feet, right where the water comes up and kind of hits your legs, as the water runs out, the sand around your feet disappears very, very quickly. And adjacent to your feet, the sand doesn't really do anything. Okay, so when you place an object that's immovable in sand and you get water and wave action on it, the scouring and the removal of the adjacent grade can be dramatic. So once again, the idea is that under FEMA and under the New York State Building Code, anything below the house should be open and allow the easy passage of water, hence breakaway walls. In our investigation of these plans, and Dan can hand out the exhibit or analysis, the walls that are labeled breakaway on the structural drawings effectively are fully reinforced. They're connected to the grade beam, which is connected to the pile. It's also connected to the structure above, which is a violation of the building code. This wall has to fail with 10 to 20 pounds per square foot of water or wave action on it, okay? Reinforced the way it is, it's not going to fail, okay? The biggest issue is that it's designed to withstand the sections that Mr. Bragman showed, the backfill or the regrading of the sand back against the walls. If it can withstand the sand that's backfilled against the walls, it can't be breakaway. Okay, so we have a bit of an issue with the fact that this is designed, the concrete slab, which should be frangible, but as it's described in the plans, it's not. It has wire reinforcing in it. It's 5 inches, not 4 inches, which is determined by code. So there's a couple of inconsistencies with how this underneath space is actually constructed and how it should behave under code. That's really kind of the main thing that we looked at. The code analysis we did, which is part of the exhibits, that Dan has, shows basically the loading, what you would expect at the top and the bottom, and some other issues. There's no flood vents, which would normally be in even previous codes. Flood vents were not required in the VE zone or in the coastal A zone. They now are. And there's some other mechanical equipment, I think electrical outlets are down there that shouldn't be. So it's really just a recognition of that space really is problematic. It's not code compliant, and it's a detriment to adjacent properties because it is a block, 700 square feet of reinforced masonry that is going to divert floodwaters and cause significant scouring and basically just displacement of sand that should not be displaced.
Thank you.
We'll talk about it.
Yeah. I'm Dan Aiello, by the way. PE.
What's that?
I'm Dan Aiello. I'm a professional engineer.
From, okay,
So can you repeat your name one more time?
Dan Aiello.
Gail?
Dan.
Dan Aiello?
Dan.
yeah, please speak into the
Sorry.
mic. Thank you.
Thank you.
Do you swear affirm to tell the truth, the whole truth, and nothing
I
but the
do.
truth? Thank you.
So I have here a little memo.
Thank you.
Issues that we found, and I did our third party review. And if you get to the third page, is the calculation that I performed.
You should just wait a minute, because, no, just get back to
Yeah,
the
speak from
microphone
the
before you
mic,
speak, 'cause
please.
if there's a transcript, we want to pick it up.
So if you were to turn to the second page, there's a little image here attachment 1 of my calculations that I performed. More or less, we proved that the pressure that you're going to see at the bottom of that wall is 660 pounds per square foot, which is over 30 times what the code allowable limit is. So if you read the code here, it more or less says a wall, so let's say this, are designed to break away or collapse without causing collapse, displacement, or other structural damage to the elevated portion of the building or supporting foundation system. Such walls, framing and connections shall have a resistance not less than 20 pounds per square foot and not more than 20 pounds per square foot, as determined using the allowable stress design methods. So basically what we proved is that you're going to have over 30 times that amount of pressure on the bottom of that wall. So based on that, it's not code compliant with New York State
That's
building
based
code.
on the reinforcing of the wall or the backfilling of the wall?
The backfilling of the wall. So just the backfill, not wave action, not, okay. So then we further analyzed, well, just to, see if it worked. So more or less, the wall fails even when it's backfilled. It's improperly designed from just a code standpoint of just backfill, not even flood analysis. So there are some issues with the design of this wall that we found. So it's kind of like this in between there. It's over-designed and it's also under-designed, if that makes sense. So it's over-designed for flood breakaway, but it's under-designed for structural performance of being backfilled with soil. So we have some issues here with that detail.
Thank you.
Okay.
Subject to whatever the team here has to say, we think that this aspect of the design that the board wasn't aware of, I believe, and when it was acting as a ZBA on the natural resources special permit, was important to show you when it came to light as a part of the flood hazard overlay application to the local administrator, who is the building inspector. That doesn't comply with the construction policy that I read to you, that you can't have artificial structures that interfere with runoff and drainage and wave action. And construction should not continue on this. Also, it's interesting that the walls and the concrete are too strong for breakaway walls on wave action, and they're too weak to support the backfilling that the architect told you he was going to do when he talked to you on the NRSP when it was in front of the zoning board. And as I said to begin with, you step into the shoes of the building inspector on an appeal like this. So you're entitled to evaluate the evidence. You can get help from an independent engineer. And we think these are very serious inconsistencies between the two plans. Watching the meeting, when the plan was presented to you, the architectural drawings don't really present the issues that are the most difficult and the most technical, and which implicate the strongest policies of the flood hazard district overlay requirements. So we think we're happy to be here so that the zoning board can substitute its judgment and go through the evidence and get whatever evidence you want, or help from an independent engineer. And basically, we think there's enough, there are enough inconsistencies with the required floodplain hazard requirements that this construction should stop immediately until they're resolved. I mean, I can certainly wait to hear what the other side says, but we think that some action should be taken.
Thank you. So we have two other firms here representing applicants. We have the Adam Miller Group, represented by Denise Schoen, and we have Michael Sinleski from the Sinleski Law Group. I'm wondering if the best avenue is, Denise, if you go, because from a time you were there from the previous application, and then Michael, maybe you can follow up with your, so Denise, come on up. And then, yeah, before, I want to hear, I'd like to hear from the opposing sides before we hear from the building inspector. I think that makes sense, right?
Yeah.
Yeah.
Good evening, Mr. Chairman, members of the board, and council. My name is Denise Schoen. I'm an attorney with the Adam Miller Group at 2461 Main Street in Bridgehampton, New York, here tonight on behalf of 22 Shore LLC, which, as you mentioned, Mr. Chairman, was the applicant in connection with this application. The applicant has subsequently sold the property to a third party who is represented tonight by, as you mentioned, attorney Michael Sinleski. First, I'd like to point out that we received Mr. Bragman's application several months ago, and we have reviewed it and responded to it in detail in both written submissions and tonight verbally. We'll do the same thing. One of my concerns is that what the application that was submitted in terms of the appeal does not point out any of the details that we heard tonight. So I didn't look at those details. I looked at the details that Mr. Bragman raised in his appeal. So some of the things that were mentioned tonight, I have not researched. I haven't spoken to the architect about. I know that the architect is here with me tonight, and he may be able to respond to some of those just right on the top of his feet, but he may need time to look at them. I also don't have my engineer, and I know engineering issues were raised. So I may need to have them look at those statements as well. So just from a procedural perspective, tonight, before I got here tonight, I didn't know that this was going to be the extent of the arguments. The arguments that I heard or that I read or interpreted in connection with the appeal were essentially around a few details. One was whether the 6-foot contour line was the correct contour line around the house, because the contour line down by the shore is 6 feet. The contour line up at the road is also 6 feet, but the contour line around the house is much higher than 6 feet. So I didn't hear that argument tonight, so I don't know if they've perhaps figured that out by looking at the survey or have determined that that was an incorrect statement. The other issue that I interpreted from the application was that we were not permitted to have what Mr. Bragman is referring to as a room underneath this building. What we've proposed is, in fact, not a room. It is the area beneath the house with pilings surrounded by breakaway walls. And all of the walls around this area are breakaway. As I understand it, the pilings of the wood that, or the, I don't know the technical term.
Lagging.
Is also breakaway. So there is no structure surrounding this, the area of pilings that is not breakaway. So that whole area is intended to fold in the event of a storm so that floodwaters can go under that area and through and not create more of a hazard by lifting anything and moving it away. One of the other issues that was raised in the appeal was whether pilings were under the swimming pool. I didn't hear that argument tonight. They are. And again, same concept. The water comes up. It's supposed to break away those walls, go under the pilings, and flow right through, not creating any flood hazards or issues with regard to the building. I also understand that it is your job tonight to stand in the shoes of the building inspector. And what the building inspector does when he or she reviews the plans applies the FEMA regulations and of course our tidal flood hazard overlay regulations. But in that review process, it is not a subjective assessment. It's an objective assessment based on the language in the code. The general language about not altering dunes or, just generally protecting the environment is really up to the zoning board when you issue your approval. It's not up to the building inspector to change the design elements of the building unless they don't comply with building code standards. And in this case, I firmly believe they do comply with building code standards and FEMA standards. So does our engineer and so does our architect. So we've submitted this in writing to you with a number of exhibits. 2 of those exhibits are written submissions by those experts directly responding to the claims that were made in the original appeal. They don't respond, of course, to the claims that were made this evening, again, because they're new. We didn't hear them. So those letters address the issues that were raised in the initial application. I would also join in Mr. Sedlensky's objection to the filing of a second addendum today. There is a statute of limitations in place on purpose with regard to appealing a building inspector's issuance of a building permit for obvious reasons. We don't want people who are trying to build their houses held up for an inordinate amount of time while people debate whether or not the building permit was issued properly. So there is a strict 60-day statute of limitations to follow your appeal. That appeal is supposed to give sufficient notice to the property owner and to the public what the applicant is appealing from, what they're appealing about. And right now, what's concerning me the most is that when I read that application, none or little of what was said tonight was in it. So that does put us at a distinct disadvantage in terms of responding to you adequately tonight. So with that, I think I would like to ask our architect to come up, Nilay Oza. I know that he does want to respond to the architectural issues that were raised.
One question that I'm going to have is, if the lagging wall, as per the structural drawings, is supposed to be cut down 2 feet and left,
Yes.
and it is also designed to be a breaking wall,
Yes.
how can it be a breaking wall when you have a pool structure right up to it? It's not doesn't have any place to move. So it's not a true breaking wall because it's what happens is the pool structure is going to impede its implosion. So that's one question that I'm looking at,
Got it.
as far as difficulty for me.
Got it. Thank you. I understand the issue. Unfortunately, as an attorney, it's above my head.
That's all right. I'm sure we can answer that.
But I promise to,
Right.
Consult with our engineer about that. I don't know how much the architect is going to be able to address that for you. But I do know that he can address some of what was raised tonight. Thank you.
Thank you, members of the board. My name is Nilay Oza Sabbath Architects.
You raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So Denise is correct. I would need my associate engineers to answer a number of the questions about reinforcing and such. I can shed some light on the lagging wall. I do recall this was a topic of conversation among us. So the principal need for this wall, as we've discussed with the board, was the need that the dunescape seaward of our excavation would be completely maintained. That was the principal design requirement that we put on the soldier piles and the lagging in between. And as you've seen in the language, including point 9, that we allow for the contractor to have some leeway in how this is done. It's not completely prescribed, it can't be. One potential example being that you cannot actually cut the lagging wall without the entire lagging slipping down and actually affecting the grade on top. You have to backfill, and only when you reach on the top can you actually access the lagging. Because if you're down here and you cut the lagging is in danger of failing. And therefore, the lagging is designed as breakaway. As the language here says, potentially leaving the run adjacent to the western boundary for septic install. So the lagging as designed in every case is breakaway. I do recall talking to the engineers about how it would be and what kind of screws would be used and things like that. So it was a topic of conversation, but I would like to say that a lot of this is left in construction terms as to what is feasible. The second thing I would like to say is about the basement floor. The New York State residential code, basically their language is basement floors that are below grade on all sides are not prohibited. We're clearly not below grade on all sides. There is 50% of the roadside that is actually completely open for water to pass through and exit out to the street level. And in my conversations with the engineers, the breakaway walls are on all four sides, not designed in any other way. Is there any specific question?
Well, on those breakaway walls, I mean, they have to be designed to withhold the backfill,
Yes,
the grade,
absolutely.
right?
My understanding is that's the way it is designed.
So in a sense, they're a retaining wall.
Well, they have to retain the soil, but when there's water pressure, they fail. I mean, there are breakaway walls in all kinds of cases on properties on the coast where they are backfilled to some level. It's not like all breakaway walls in places that are below BFE have no backfill against them. They're completely open, void spaces. And this is a pretty common situation.
No, I understand the breaking wall.
Yeah.
Okay.
But as I said earlier, it's an expertise that I wouldn't want to speak to because it isn't mine. So, I would like to have the engineers who work with us on this speak to you about it. But would like to again underscore one of the reasons for the soldier piles and how this design is done is principally to conserve the dune on the seaward side. That was our principal motivation.
Okay. Thank you. Any questions?
No.
Who's next? Michael?
Thank you, Michael Slunsky, again, for the property owner. Mr. Chairman, and through to the members of the board, there's a number of things here. Number one, Mr. Bragman is the applicant. If you look at the application, he's listed as the applicant. It's not disclosed that anywhere that who his client was until this evening. So we appreciate him disclosing that, so we know that. We also appreciate him disclosing tonight what his true problems with this application are. Because if you look at the application in the addendum 1, there's nothing about a wall in that application. They talk about the basement room underneath. They talk about the natural contours, but none of this is discussed. So I would ask the board, is this rightfully before the board? Because all of this is submitted more than 60 days after the time frame upon which they can challenge. None of it's included in the application. Even when he adjourned this application, my client got no notice of it. My client got no notice of this application at all, other than the fact that I have another application on tonight and we saw that it was on. And we had represented the client at time of closing. And that's a problem in the town code. It doesn't deal with this board because it says notice has to be given to the owner of record. And the record, as you know, Suffolk County won't update their records for 9 months to the town. So it's only by happenstance that my client knows of this. My client's entitled to this building permit that was issued. The building inspector who's here tonight and who I hope you listen to and talk to tonight, went through the process of looking at all the plans and issued a building permit, and my client has started construction. My client shouldn't be held up from starting that construction. I know Mr. Bragman stepped to this microphone and somehow seemed to be insinuating at the end of his discussion that this board had some power to stop my client's construction or to halt my client's construction. He's doing a good job at delaying my client's construction, but my client's entitled to move forward with this building permit. This building permit was rightfully and properly issued. The only thing that's not right and proper is this application before the board, because this is a application by ambush. None of this was discussed. All these plans were known. We don't even know where they got these plans from. Maybe that would be interesting to know, where they got copies of our structural and diagrams from, because as far as I know, the building department policy is that they can't be released without the signature of the owner. So that would be interesting to know. On top of all of that, none of this was discussed in the application. And I would posit to the board that none of this is timely before the board, except for the one issue regarding the basement, the quote-unquote basement room, or whatever they want to call it, which you've heard from the architect is completely designed to be break away. And I think when you hear from the building inspector, he will agree with that. The lack of pilings, which you can see that there are pilings. So I would posit to this board that most of what you have in front of you, most of the testimony you've had tonight is not properly before the board. Thank you.
Thank you. All right, let's hear from Joe Palermo, Chief Building Inspector. Come on up, Joe.
Good evening, Joe Palermo, Chief Building Inspector, Town of East
Do you
Hampton.
swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go for it.
Oh, okay. So I personally reviewed the application because I knew it was kind of high profile. I went over it several times. I was satisfied with not only the architectural plans, but as much as I know about the engineering plans. I went over them a few times. I made sure that I read the language of the breakaway walls. That basement storage area, there's no access to the house, it's strictly storage. It's designed, it's saw cut, it's designed to break away. And there's at least one side that's completely exposed, which would allow some flow through and some breakaway. It's not totally concealed within that dune. I mean, honestly, as far as the dune goes, I went through the construction protocol, and I was satisfied with what was given. I also put some faith in the board, the planning board, zoning board, when it comes to the natural resources end of it, while I handle the construction end of it. Once again, there were, as far as the application on the appeal, there were certain points there that could simply be argued, as far as the engineering of the breakaway walls, which the engineers spoke of so eloquently. I can't really speak to that point because I haven't heard that argument before, and I haven't seen the documents either. So that's like an engineering a little bit. I would need an engineer to really check that out for me. But as far as what I saw in the building plans, when I reviewed it, I was 100% satisfied.
The original application primarily dealt with the FEMA aspects of the application, if I recall. So you reviewed that as well, right? You want to speak to the FEMA elevations and aspects of that?
Correct. It's high velocity wave action zone. This house is built landward of the coastal erosion zone. I believe it's the secondary dune, there's a primary dune before it. And I make sure I check the elevations, well, double check, triple check, make sure we have that right. In this case, everything was compliant as far as I could see as far as FEMA goes.
Okay. Anybody have any questions?
I do not. Do we have the date? What date was the building permit issued?
Building permit was in January, correct?
January?
Yes, I believe like towards the end of January.
Yeah. Any other questions for Joe? No. Thank you.
Thanks.
Anybody in the public would like to address this application? No? Michael, do we have anybody online?
You have 0 calls on the line. Thank you.
Okay, thank you. Council, you have any additional? We'll give it.
I'd like the structural engineer to make a comment on the wall.
Okay.
And whether it's breakaway or not. And then,
Didn't he did already, didn't he? Oh, come on up.
So again, with the lagging wall, it's
You have to
designed to,
identify yourself for the record again.
oh, Dan Aiello, from H2M Architects and Engineers. Okay, so it's same concept as that basement wall, we'll call it, that's backfilled with soil. It still has that same amount of pressure on it. So if we read, I could read the code again. So it's, again, are designed to break away and collapse without causing collapse, displacement, or other structural damage to elevated portions of the building or supported foundation system. So I guess I'll stop there. If that does collapse and that does break away, it would undermine the pool and the pilings per se, because that is higher. So I will put that at that. And then such walls, framing, and connections shall have resistance not less than 10 and not more than 20 pounds per square foot. So again, we're exceeding that with the same amount of soil pressure on that lagging. So it can't be considered a breakaway wall per the New York State Residential Building Code. It has to be below 20 pounds per square foot.
Thank you.
What's that?
Denise Schoen, what? Jeff, are you?
one more.
One more? Okay, quick.
Just a couple of things. In deference to Mr. Palermo, the plans as presented to the chief building inspector are code compliant. So you are allowed that space below if it does contain breakaway walls. But once again, in analyzing the detail from the structural engineer, the wall can't be considered breakaway because it doesn't meet the requirements of the 10 and 20 pounds. Same thing with the lagging wall. It can't be considered breakaway. It's holding back 16 foot of dune currently. So if it was a breakaway wall, by code definition, it would collapse because you've got 16 feet of soil on the seaside pushing against it. So once again, the review of the plans in terms of code compliance, these plans are code compliant. The details are where it kind of falls apart really quickly. And the other point relative to flow, New York State code requires opposite sides of the walls below BFE to have openings in them to allow that flow. It can't be one-sided. It has to go through, not come in and go out. So once again, on the plans, there were no indications of any flood vents or any provisions to allow seaward side water coming through to land side. And once again, that's...
Are flood vents required in a breakaway wall?
Flood vents previous to the last code? No. Under the current code, yes. I was surprised at that too, because typically in a breakaway wall, the wall breaks away. There's no reason for a flood vent. But what the code is addressing is if you don't have that level of velocity of water, it won't damage the wall. It'll just use the flood vent. So, but it is new to the code. And actually, there's a technical bulletin FEMA issued in, I want to say, October of last year that covers the flood vents in VE and Coastal A.
Okay, thank you.
Thank you.
Just one quickly.
Okay, Jeff.
Jeff Bragman, for the applicant, who is not me. It's the client I previously identified. I just wanted to say, in reference to what can be done or what should be done, that under the floodplain district requirements, deficiencies that come to light in a construction project shall be cause to issue stop work orders unless they're immediately corrected, no matter how the deficiency comes to light. And that's section 255, 343, D4C. So whether it comes to light in an appeal or a letter to the building inspector, at any time, it's cause for an immediate issuance of a stop work order and correction. And what we're saying is you've got that problem here, and it all relates to the way they're creating that room below, because that wall is a part of what enables them to do it. And supposedly they're backfilling against that wall once it's up. That's their intent. Once they build the other structures to lift up the pool and do what they need to do on the house, they're backfilling. So that wall is a part of creating that basement space. It all connects to the basement space. But it's not a breakaway wall. They're not breakaway walls. In the space, the concrete isn't breakaway. And when deficiencies come to light, it's cause for issuance of a stop work order and immediate correction, because this is life and safety. Thank you.
Thank you. Denise, can you come up? I've got a question for you. You mentioned that you wanted to talk to your structural engineer. We have a couple of things going on here, right? So we have you wanting to talk to your structural engineer. We have Mr. Sandleski saying it's time barred. So go for it.
Okay, so after conferring with my colleague, Mr. Selensky, I agree with him that the arguments made tonight are time barred. Honestly, I wish they had been brought up 60 days ago when we received the application, because as you know, I would have come here prepared to respond to those issues, but none of them were raised in that application. They were, as I said, general objections to building in a FEMA zone, and then the two specific objections that I mentioned earlier turned out to be, I think, just errors. Didn't see things on the plans. So what I would request is that the board close the hearing for the evening and render determination whenever it's convenient for you.
Okay.
Thank you.
Thank you.
I'd ask for an opportunity to submit something in writing.
Regarding what? You've had the chance tonight?
These issues on...
So argue it now. I think we should argue it now, and I think the board is going to. I don't think we have a day. We have a potential, right? We have a potential of a building permit either being falsely made or given, and we have a job site that's hurting a client that's if it was legitimate, that's costing him time and money. So I think we should be efficient in our time here. So if you have an issue, argue it now, because, I think that's the best thing to do.
Well, my issue is that
council advises me otherwise.
the deficiencies that we talk about do relate to the interior room, and they go out from there, because the room couldn't exist without the structure without the seawall that's protecting it. It's clearly not a breakaway wall. It's holding back too much soil. But
we've heard from your experts regarding that.
Okay, all right, then I'll rest on what they said, and I'll wait your decision.
Thank you. All right, can we have a motion then to close the hearing?
Well, just wait. Mr. Bragman, when the deficiencies were discovered, did you go to the building department? Did your client go to the building department?
I've been to the building department several times on the case and discussed deficiencies with the construction. But what's true of the building department on this case and on any case is that, and I can cite you Chapter 102 of the building construction law, that if it becomes apparent that a project is in violation of code, it has to be stopped. It doesn't matter when it's discovered. The building inspector always has the ability to stop a job and get corrections, and that's because the drafters of the building code and especially the floodplain hazard code understand that life and safety are implicated in these kinds of violations. So you don't get a vested right to continue to build something that violates a structural requirement in either the flood code or the building code. It doesn't matter when it comes to light. And if a building inspector has acted in error, it doesn't matter where the construction is. There's no vested right that comes from that. Again, because the law is written to encourage compliance, not to let people get away when a building inspector makes a mistake. It's too important to let that mistake stand. That's the way the law works. It's in the building code 102. I can cite you the section, and it's also in this code. And you have the right too, as a board that looked at the natural resources special permit, if something was not disclosed to you, to rescind your permit on the grounds that something was omitted that should have been represented to you. And that would be my position about this unbreakable seawall, and also about the failure to properly design these breakaway walls or breakaway concrete. It's just not there. You can't let it stay. It's too dangerous. This is why we have this code, because when you have structures that won't break properly, they break and they create debris, and they can damage property, and they can kill people. That's what you have here. It's a tough decision, but that's why it comes back to you now. But the law is pretty clear. Anytime, you don't get a vested right if a mistake was made.
In this case, it is stopped at this point. Construction is stopped?
I don't think it is. To my knowledge, it's not. They were working on it today. There's no.
During the middle of the day, nobody was there, and fence was across it.
I think my understanding is they're working on it.
Okay.
And
Okay, well, what I wanted to know was there a date that you went to the building department when this
I
was
visited the
first,
building department several times and the town attorney's office several times in the case.
prior to putting in the application?
Yeah, I did.
Thank you. Should we have a motion to close?
Close the public hearing and record, yes.
And the record. You go for it.
In the matter of the appeal of Jeffrey L. Bragman, 22 Shore Road, Amagansett, Suffolk County Tax Map Number 300-131-8-7, I make a motion to close the public hearing and record.
Second.
Concur. Thank you. Thank you.
Yeah. I like it when it's like this. I can never get like this.
You had time for dinner.
I should have had dinner.
Good.
It's unheated, it's air conditioned, and it's really cold.
How are you, Keith? Oh. All right. Hey, Keith.
Edge, right?
Okay.
So next.
For this one.
So we have to have a conversation first.
Well, everyone's gone.
Council, we have our next application hearing. We have an issue. Should we read it into the record or should we discuss this first?
Yeah, read it into the record so the minutes are clear what we're talking about, if you don't mind.
So our next hearing is John Zuccotti at 91 Waters Edge in Springs, Suffolk Tax Map number 300-83-7-8. The size and location is 10,819 square feet. To the top of the bluff, 20,932 square feet total at 91 Waters Edge, lots 135, 136, and 137, Barnes Landing, Section 3, filed June 15, 1956, map number 2572 in Springs. The description is to reconstruct 97 linear feet of an existing bulkhead in place and in kind, and to allow existing slate walkways, fences, AC units, and outdoor shower to remain on a parcel containing a bluff and tidal wetland. The relief sought is a natural resources special permit pursuant to 255-420 of the East Hampton Town Code, and 3 variances are required for this application. 2 variances of 18 feet, 21 feet from 255-440E1 of the Town Code are required to allow the AC units to remain 57 feet and the outdoor shower to remain 54 feet. From the bluff crest where 75 feet is required, and 1 variance of 255-440A is required to allow the wire fence to remain on a seaward face of the bluff crest and any other relief necessary. The zoning district is B residence, BE 12 flood zone X, and the secret class is type 2. Council, do we have proper affidavit of service and posting?
So I do have an affidavit of service and posting. It appears that everything is in order according to the affidavit. Prior to tonight's meeting, when Vice Chair Severis went to conduct her inspection, she noted that there was no poster. I believe the applicant and the applicant's agent, or at least an agent, is here tonight, so they're aware of this. It was thereafter posted, so we do have a photograph in the file that a poster then did reappear yesterday. In an attempt to try to save everybody some time on having this discussion tonight, I did relay this question to the board to kind of give the board the opportunity to decide. We have, in my mind, at least 2 options here, but the 2 that I presented them with were either we do this, we open the hearing, we note that at least we are aware that there was no poster for some amount of time. We're not sure how long that was. And to leave the record opened perhaps longer than, if everything was all tied up and done, we would leave the record open longer to give the public an opportunity to participate. The other option was that we would not open the hearing tonight and require it be reposted and renoticed for that exact set of circumstances, because we know that the poster was not up for the entire 10-day period prior to tonight. When I sent the email, I did hear from the 4 members who are here tonight. I did not get I don't know which way we were going to go. I was waiting for Ed, who, as you can see, is out sick tonight. So I don't know what the board's pleasure is.
Go ahead, Denise.
I'm of the opinion that it was good faith put in submitting an affidavit. And yes, they should be posting the property for 10 days. But in the past, and quite recently actually, we have left the record open. In this particular case, I'm willing to go forward with having the public hearing to save everybody's time, because I would just recommend that we leave the record open for the 10 days and post it properly so that the neighborhood is aware. And the only reason I'm willing to do that is because there was a good faith in submitting the affidavit, and they did try to follow the process. I don't know at what point the sign fell down, or, we don't know that. But we have quite recently made exceptions with conditions that the record be left open. And in this particular case, I would be willing to go forward tonight with the record being left open for the property to be properly posted.
Thank you. Jane?
Thank you. I visited the site yesterday morning, and I also was noticed and surprised that there was no sign of posting. Often we go to sites and we'll see the board and the pole, and then we'll see, the posting is sort of blown away by the wind or something like that. I'm of two minds. I really do think that the public has a right to expect a full 10-day posting. It serves a purpose. It's very important for, what a public hearing is about. And I think as a board, we have a responsibility to uphold that, part of the code and part of the standard. I know leaving the record open post the hearing has been something we've done before, but, I do think there's something to be said when the public participates directly in the hearing. Many times I've seen this board, listen to something that was said or submitted to the record and then ask the applicant about it. And, there's a full conversation about something perhaps that a neighbor might bring up, or a member of the public, and then it makes a better record. So all those reasons, I think that we do need to establish, definitively the seriousness of it. On the other hand, people wait a long time to get in front of the board. And I don't, and I understand why we haven't necessarily held firm on everything. I think ultimately we as a board need to really establish a full protocol and regulation. And also I just want to say that anything I say that might sound about wanting to not move forward is no way at all any sign that I have any pre-existing negative, thoughts or anything. It's nothing to do with the elements of the application.
Thank you. Terry?
Well, I've said this many times before. I believe that the full 10-day posting period should be observed. And there are times also, when we don't keep a hearing open, there are times I've run down agents to say it's down, go put it back up. And that's happened too. I fully believe that anybody driving by a property, whether they've been noticed because they're directly adjacent to the property or not, is entitled to know what's going on and may be interested. And the more interest we get out of the public, I feel is a good thing.
What is the requirement in the code?
Well, it was in the newspaper.
No, as far as maintaining, there's a maintenance required on the posting, isn't there?
Yeah, it's required. It's called out separately in the code for posting a notice.
Yeah, I don't want to misspeak, and so I can find the section and read it. But the code establishes the 10 days, and I believe also, case law does support that it is really the obligation of the applicant to maintain it for the 10 days.
So I know on numerous occasions that we've had this before. Again, sign blowing down. I do agree. Most of the time there's evidence that the sign was there. There were evidence when the sign wasn't there that this board has always given it a leeway for a post-posting. I do understand the fact that the reason it's up there is to get public participation in the hearings. That I get. So I was leaning on more allowing the board to move forward tonight, but that gives us a 2-2 situation.
Well, at what point do we stop doing this and follow what the code says?
Yeah, well, just so, because I have it, 255-923 is notice and hearing. And then paragraph A2 by requiring the applicant to erect a sign measuring not less than 2 feet long by 1 foot wide, which shall be prominently displayed on the premises facing each public or private street, which the property involved in the application abuts, giving notice of the application, the nature of the approval sought thereby, and the time and place of the public hearing thereon. The sign shall be made of durable material, shall be set back not more than 10 feet from the property line, shall be not less than 2 feet nor more than 6 feet above the grade at the street line. The sign shall be displayed for a period of not less than 10 days immediately preceding the date of the public hearing, or any date to which such hearing may be adjourned. The applicant shall file an affidavit that he has complied with this provision.
So we don't have a photo of the original posting?
No,
No.
do not.
Do we know if do we know how it was posted? Was it posted with a sign, with a sturdy thing?
You said it was
Yes,
My office posted it, it's stapled to the.
Hold on, you should come up.
okay, stapled to the telephone.
It's just gonna, I don't think
Come on
it
up,
picks you
come
up
on
from
up.
back there.
How are you, Keith?
Good.
I'm gonna have to swear you in, so announce yourself.
Keith Grimes, contractor,
You swear
permit
affirm to tell,
applicant,
do you swear affirm to tell the truth, the whole truth, and nothing but the truth? I
nothing
know.
but. And it's particularly relevant now. My office did post it. They stapled your notice of hearing to the telephone pole that's shown in the same picture you just showed. Sorry for the inconvenience. It's a bit out of our way over there on Water's Edge for us to really do a drive-by. But I can say with complete confidence it was posted.
For me, I'm satisfied with that. That's for me.
I am too. With the understanding that it be posted for 10 days.
But I'd just like to get the hearing portion of this. I have no objections to the extension on the, leaving the file open.
Thank you.
So where are we?
I know, I don't want to have to be the one to make the call because I wanted the board to have to decide this. But also,
This is what you said.
Doesn't want to make the call.
thanks for this, Terry. No, I'm just kidding. While I sort of agree academically more with the two that are saying we should postpone it, I know that we, usually accept this type of now testimony, plus we have an affidavit, plus we have a photo with the, additional accommodation to the public of leaving it open on the tail end. My opinion is I think the right thing in this circumstance is to open it now with a very clear public discussion that moving forward, what it doesn't state in the code is, to provide a photo for the record, but that seems to be what we rely on more and more.
Yes.
That would.
The photo doesn't show that it was there for 10 days either.
I know it doesn't. I know, but at least
it does anything. That's kind of a mood issue.
Yeah, you could be right. I mean, but oftentimes we say, well, at least we've seen the photo. I mean, we did that 2 weeks ago. At least if we had seen the photo in the first place, we would have established that it was there in the first place even. But to me, what I normally am supposed to be looking at is that the affidavit is dated properly, that it's affirmed.
Court of law, an affidavit holds a huge amount of weight, right?
Yes.
So
can
And
I?
if there wasn't an affidavit, I wouldn't feel this way. But I think there was a genuine effort to comply, and for some reason, the sign came down.
May I add a thought? So I understand what everyone's saying, and as I said, it was of two minds. So I'm not being, monolithic in saying I don't want to move forward tonight. But what I would like to say is sort of, that we have to really establish the requirement, the expectation the burden on applicants, even if we have to write it down somewhere, and then moving forward.
Down.
I know, but.
Yes, I agree with you.
But we do have an affidavit, and I'm understanding
Yeah.
from a legal perspective why
So,
that's, so I just want to say, this would be my last time.
So I'm just going to recommend,
Okay.
I'm going to recommend.
I will agree to tonight if this is the last time we do this.
Okay, so you have a point, and I'm going to say this. I think it's been the policy of the board to move on and do that. I think we can, if you wish as a board, I think we can in the future establish a new policy, get it out there that the board has a new policy, you know, we're going to be a little bit more stricter on your postings.
Yeah.
And I think maybe from now on,
Right.
I think we,
We have to stick to it.
yeah.
There's a section of the code, that says we can establish policies.
We
So we have a report for this. The application is read into the record. Do we have a report?
I do.
Okay, thank you.
I think I lost 10 pounds doing this field inspection.
Did you go up and down the steps? Very
Okay.
impressive.
This is, obviously, there was no posting, but there's the mailbox. I am at 91 Water's Edge. Next, please, Morgan. This is, I'm about to, well, it's obviously a gravel driveway, but I'm about to enter the, where am I? The north side of the property, up the stairs. Next, please. This is still the front, from the roadside on Water's Edge. It's a very pretty rock wall. Next, please. And this is a view of the house from Water's Edge. Next. This is the north side of the house, and that little deck you see, and these are the walkways before us, and that little deck that's there, right beyond that, and I think I've indicated it in another photo, is the outside shower that does meet setback, and I believe it's on the CO. And that is the entrance gate. This is the next, that's okay, Morgan, go ahead. This is the back deck. Just a picture of the back deck. Next, please. This is also on the north side of the property beyond the first outdoor shower, because there are actually two on this property. This is the units before us, which are on the north side, and they're kind of hidden behind, and I'm sure in the summer you don't even see them with the hedge that's in front of them. Next, please. All right, where am I? Oh, this is actually the existing shower that does exist on the north side of the house. And this, if I'm correct me if I'm wrong, Morgan, I believe this is the outdoor shower that is legal and is listed on the certificate of occupancy. Next, please. These are steps leading down to the backyard. This is also on the north side of the property. Next, please. This is the fence before us. It's currently seaward of the bluff, but very heavily vegetated bluff. It's actually quite pretty there. And not really sure. One of the things I want to address is the location of this fence, and we'll talk about it when we get into the applicant or the agent's presentation. Next, please. This is just to give you an idea. This is actually a very steep property. This is probably the most pictures I've ever taken for a field inspection. But this is it's a very, very steep property, and it's hard to pick up in my cell phone camera, but just that's what I'm trying to indicate in this, and it's leading to the edge of clearing. But next, please. Again, another visual of the steepness. We're actually starting to walk toward the east side of the house where the edge of clearing is, and then the fence, and then the stairs. Next, please. This is actually the first set of stairs. I'm very proud of myself. And there are actually, I think, well, as this will show, but I also took a photo almost of each staircase and landing to indicate the vegetation, because the bluff is really nicely nourished with vegetation. Next, please, Morgan. Just another example of the vegetation along my path to the bulkhead. Next, please. second set of steps that lead down to another landing, which will bring us down to the bulkhead. Next, please. Where am I? I think this is just another example of the vegetation that exists along my walk down to the wooden bulkhead. Next, please. Again, heavily, the bluff is not, it's really vegetated very well. Next, please. I just like this tree. I thought I'd take a picture. Next, please. The third landing that leads down to the third set of steps that leads down to another landing. Again, along the way on both sides, it's very heavily vegetated. Next, please. Just another example of the vegetation. This is the, obviously the bulkhead that's going to be reconstructed, I believe, 97 linear feet of wood bulkhead. Next, please. And this is the timber groins that are at the very bottom of the stairs. They're right there as you walk down to the first part of the wooden bulkhead. Next, please. Just another visual of the bulkhead and some of the other timber. There are other timber lines that are perpendicular to the shoreline that extend along this area. Next, please. This was an interesting, I don't know, these look like dilapidated steps that are really just sitting there. I wondered, actually, to tell you the truth, they're so open to the water. The property is so well maintained, it just didn't seem in keeping with the property. So it almost, maybe they can address what this is doing there, or did it actually come in through a storm surge, or did it wind up there from the water? I'm not even sure. Next, please. This is just a walkway, the end of the walkway at the bottom of the landing that leads to the revetment and the timber groins. Next, please. All right, where am I now? Okay, this is on the south side of the property. This is actually the second outdoor shower, that structure that's coming up toward. And this is the one that's actually before us tonight. Next, please. Just took pictures of the shower inside. And there might be another one with the plumbing. Yeah, there it is. Okay. Next, please, Morgan. And this is the gate on that south side. On both sides of the property, north and south, there are gates that lead out. Next, please. This is just a photo of, I'm standing in front of Gardner's and I'm taking a photo of the back part of the house. And what you're looking at is the deck, all the decking that is along there. Next, please. I think that might be it. Oh, where am I now? Oh, this is just the steps leading back down from the north side down to the gravel driveway. I don't know why I took that photo. Next, please. And again, it's just another visual looking from north to south. Next, please. And this is just when you pull into the lot. This is the gravel driveway that exists before the garage. And it has a really pretty series of rock walls all around. Next, please. And these are the walkways before us. These are on the, I believe I just saw them on the north side, and I don't see them on the survey. Next, please. Okay, this is where I just, in the course of the presentation, when I came back up the landing of the stairs, I just saw this black pipe and this equipment attached to it. And next, please, Morgan. And this is just going to be a series of shots because this pipe goes, or hose, I don't know what the function of it is for, especially with 2 outdoor showers. But I just wonder what the purpose of this pipe is, because it goes from the top of the stairs to the bottom, right to the wood bulkhead. Next, please. And again, this is the faucet. I believe this is at the top of the property. Next, please. And again, all this piping is all along, as you walk up the stairs, the piping goes from the bottom to the top. Next, please. That might be the last photo. Thank you, Morgan.
Thank you. Do we have the applicant here? How are you? How are you, Deborah?
Great. How are you doing? Good. All right. Good evening, Chairperson and members of the board. I appreciate that we're going forward this evening. I'm Deborah Choron of Matthews, Kirst, Cooley, and Choron on behalf of John Zuccotti, the owner of 91 Waters Edge. The Zuccottis unfortunately couldn't be here tonight, so they recently retained our firm to be able to appear on their behalf. So they send their appreciation for your time and their tuning in live from home. So they're remaining actively engaged. Keith Grimes and his associate is here. They prepared the original application, which is only natural because the main objective of the application is the reconstruction of an existing bulkhead. And from the outset, with regard to the bulkhead, I would note that the building department's files indicate that repairs to this bulkhead have historically been approved by the town, the DEC, and the trustees. And we appreciate the planning department's technical analysis memo expressly stating that the planning department does not have objections to the bulkhead's reconstruction, since work of this scope is fairly routine in this part of town for maintenance purposes. So Keith Grimes, Inc. already obtained permits from the town trustees, the New York State DEC, the Department of Army New York District Corps of Engineers, and the New York State Department of State already issued a letter in concurrence on finding that the proposed activity in removing and reconstructing the bulkhead meets the department's criteria. So all of these permits and correspondence have already been submitted to the board. So a lot of the work has already been done to get to this point by people other than me, and your approval is the last piece of the puzzle. Of course, when it comes to the technical aspects of the bulkhead's design, function, and construction protocol, I would defer to Keith Grimes and his associates, who are far better suited than me to answer those questions. My purpose in being here is to address some of the questions raised in the TAM on behalf of the Zuccottis. I'm also happy to try to answer any other questions that come up throughout our discussion this evening. So besides the bulkhead, this application seeks relief for AC units, slate walkways, fencing, and an outdoor shower. With regard to the AC units, again, I appreciated the planning department's analysis. I have to agree with the TAM statement that since HVAC units are small accessory structures that are frequently associated with residential development, the planning department does not expect substantial environmental impacts from them. I would also note that the only neighbor who would theoretically be impacted by these AC units wrote a strong letter in support of the application, stating, "We have never had any concerns about the location of the air conditioning units. We have been aware of these structures since the time they were installed, and they have never posed any problems or concerns." I submitted this neighbor's letter to the record earlier today, and I would also note that the neighbor stated more generally that she is in complete support of the planned work. In fact, she is grateful for the Zuccotti's thoughtful and timely attention to this critical maintenance. I also appreciated the planning department's analysis with regard to the wire fence on the north and south side of the residence, as well as the slate pathways. In the TAM, the planning department noted that these items do not require variance relief, they merely require NRSP relief, and further concluded that these items are minor in nature, so there are no anticipated substantial environmental impacts from them. So mainly the TAM asks the Zuccottis to explain the need for the outdoor shower and wire fencing seaward of the bluff crest. So while I'm always happy to go through the legal standards for variances and natural resources, sometimes the practical answer is helpful as well. So with regard to the desire to have the fencing, the Zuccottis have a 4-year-old beagle named Roxy who enjoys the fenced-in yard as any dog would. With regard to the location of the fencing being seaward of the bluff crest, it's the Zuccottis' recollection that the fencing was placed in its current location around the time they actually revegetated per a condition of a prior approval. So they've actually revegetated inside that line of fencing, and they enjoy that aesthetic of their native plantings while maintaining the safety and security of a fenced-in yard for their dog.
The only question I would have with that is, then if there was a required re-veg, the re-veg typically would have been landward of the bluff crest.
Yes, it was. So the fence somehow ended up on the other side of that line of revegetation, if you look at aerials. So basically, they have revegetation that they did that basically shields their fence. So I think the fence is closer to the steeper part of the embankment where the
Well, it
re-veg.
is definitely on the
Yeah.
steep part, but would you have any objection to putting it
The edge of
at
clearing.
the edge of clearing?
So I don't,
Because,
yeah.
yeah.
So in informal discussions with the Zuccottis on this issue, we were kicking around two things about it. Number one, they really do enjoy looking instead of at a wire fence. They love their native species that they agreed to plant, and they did in fact plant, and they do maintain. And then just as a matter of practicality, there was no malintent here, and I do think it would be more disturbance to that really steep incline to take up the wire fence and then put it in a new location. I just think if everything's doing well there, why disturb the status quo? That's my take on it. And I think that you can see how well that bluff is doing with vegetation as it is. So that would be my hard sell as to why it should.
The fencing wasn't on the, it's on the, not on the last CO 2010.
Right, I understand that. Yeah, that's why we are looking to legalize it in this application. So
Would you, to get back to the question, you would be objective to, because you are asking for a natural resource.
We are, yes.
So you would object to bringing it to the edge of clearing?
Well, we do think it meets the criteria because if you look also as I was going to get a little bit into the presentation, the neighboring properties, when you look at aerials, all of them have fencing there. If you're a prudent property owner here, you're going to have that because it's just so steep and it's not very safe. So you're definitely going to have fencing. When you look at the historic aerials of all of the properties on either side, going in either direction, all of them have fencing, and actually the Zuccottis is slightly behind where most others are a little bit more seaward. So we do think that it satisfies the criteria to obtain relief because it is certainly within the standards of the neighborhood. It wouldn't change the character of the neighborhood, in other words. We don't think it would.
I would just say that historically, though, that the zoning board would look for fencing at the edge of clearing. Why? So that we don't get it mowed into and stuff like that and mowed down. It's a critical buffer before the bluff crest is critical for the bluff.
Right, yeah. And to that, I would say that on this particular property, the aerials show the Zuccottis have owned this since 2009. I was looking at the aerials today. They did do that re-veg. They have maintained it and they do enjoy it. They're not looking to creep up that line of clearing to that fence. They haven't done that and they don't intend to do that.
Could you explain the reasoning behind the 2 outdoor showers?
Yes, I would be happy to. Okay.
It kind of defeats the other conforming.
I know. So one thing I do want to say before I jump into my written presentation on that is when you are looking at the 2 outdoor showers, the one that we are not seeking relief for, it's not, it's pre-existing non-conforming. It would itself require relief if we were applying for it today. So we got to pick our poison here with relation to which shower we want. So obviously, the older shower, which is not the subject of this application, is located off of the kitchen. So the shower that is the subject of this application is off of a bedroom. And the plumbing for the shower was already in existence when the Zuccottis purchased the property. So they found themselves using the shower that they're applying for instead of the older one, and it evolved to have the cedar siding, but it was never the intention to be greedy and be using 2 and have 2 superfluous outdoor showers. If the dual showers are a sticking point, they would propose to remove the older one. It's simply not pleasant to take a shower immediately adjacent to your kitchen where other people are cooking and hanging out. Yeah, and
but that wouldn't. But if it's not a legal shower today and you're seeking relief from it, it wouldn't be considered pre-existing non-conforming. It's non-conforming.
Right. So the one that we are proposing relief for, that one is not pre-existing non-conforming. The other one, I was just noting that that would need similar relief if we were applying for it today.
The one by the steps on the south side?
On the kitchen
On the
side?
north
The
side?
one on the north side by the kitchen is the one that
Is also
needs
pre-existing
setbacks.
non-conforming?
One is pre-existing non-conforming,
See,
yeah.
This one here.
That's what Tim said, yeah.
Right, okay, my bad.
The
All
one
right,
Yeah.
on
I'm
the
sorry.
south side is the one that doesn't meet
All
the.
right, I thought that was a conforming shower.
Right, so neither of them would be conforming to the,
You had to pick a shower.
if we had to pick a shower, we definitely want the one off the bedroom, not off the kitchen.
You'd want the one on the south side.
Right, the one that we're applying for, that's included in this application.
Fish carve out.
Yeah, so again, the practical answer, better than the legal answer, you don't want to walk through your kitchen in a towel when you have guests over. You definitely want to be using the one that's off your bedroom. And that is how this one kind of evolved. You know, at first it was just, you can even see in the photo, it's older piping, and that's what they were using, not using the older shower. So considering that both of these have been in existence without incident, if we're going to pick our poison here, it would definitely be the applicant's preference to pursue legalizing the new one that is the subject of the application.
Is there already a dry well for both showers? Dry wells for both showers?
I'm not sure.
I don't think so.
Yeah, I don't believe so.
Definitely not one on the north side.
Okay.
I didn't see one on the south side, to tell you the truth.
Okay. It looked to me like the pre-existing non-conforming one is like almost raised.
Come on. Let's see mine.
Oh, sorry.
So, final question.
Sure, no problem. You can ask as many as you want.
I'm just curious about the piping, the black pipe and
Yeah.
what's that all about?
I will have to get back to you on that. I'm not sure that's hadn't
It
been
goes
brought to
from
me.
the top of the steps all the way down, which is quite an extensive way.
Yeah, I could see that.
Wondered what the function of it was. It looks like.
Oh, perfect.
You'd have to come up, Keith.
Listen, as you mentioned, the vegetation.
They have to come up.
You can't speak from there.
Oh, yeah, it's very plush. So is that,
Keith Grimes again. I've had the Zuccottis for a customer for a while. The vegetation is as lush as it is because they put a tremendous amount of energy into it, irrigation being one of them.
that's what that is.
Okay, and with respect to the fence that you were discussing, the way that's set up now is a byproduct of that lush irrigation because they just keep watering it and it just keeps expanding. At one time, that fence was at the edge of the clearing. The vegetation has now grown through the fence and covers it.
With all due respect, Keith, I think that lends to the question of whether we should be irrigating bluffs.
I think
That
if
too-
you look at it, it's not like a permanent irrigation, but I know we did a bulkhead next door for them 15
And
years
it's not a
ago.
spray, it's a hose. So the
No, I
water
know,
is
but it's just a matter of they need to
that hose.
water that stuff. When they planted all of that bayberry and all of that other stuff in there to get it going, they put quite a bit of work into it. And I believe that black PVC pipe, that 1-inch poly, is how they managed to get water down.
We'll hear from the planning department too on that, I'm sure.
So can I just clarify you're irrigating the entire face
No.
of the bluff, just at
No.
the top?
What
where
it
it's
is
been
they
established?
planted that. That bluff, if you did go back in older photos, you'd see that bluff was pretty bare at one point. And it's got a really tough exposure as far as the northeast goes. They put a lot of work into getting that vegetation that tight. And they need to
Nicely
water to
done,
do it.
that's for sure.
Very nicely done.
All right.
Can I ask one question about the fence again? Sorry.
That's all you want.
Thank you. So obviously I'm looking at the survey and, you can see the bluff crest line and then you see the wire fence line. Obviously at some point, I don't know if they're exactly the same. It looks like there's a bit of more of a diversion in the middle. Do you know the largest area that it extends beyond the bluff crest?
I don't. I can get that measured and submit that to the board if that number helps you in your decision. but I don't know that off the top of my head.
You mean how much the bluff crest is above sea level?
No, I'm just looking at on the survey, the line that it depicts the wire fence and the line that depicts the bluff crest.
Yes.
And in some places, they're like on top of each other on the survey, and in other places, there's a bit of a space. So I was just trying to understand at the widest part, how far over, beyond the bluff crest is the fence. That's all I was trying to get to.
It's not far. I mean, I couldn't, I should have measured it because, you know.
The bluff crest is sort of an arbitrary, you don't know.
Yeah, exactly.
It has to be marked.
I mean, visually, it looks like it's right at the edge, right? Like when you're.
Yeah, and I'd say when I was looking at the area, the historic
here's the
aerials, it looks to me like most people have their fences in both directions along that bluff crest and maybe even a little beyond. And when I look at the aerials as a line, it does feel like the Zuccottis are a little bit further back in actuality than some of their neighbors. So to the extent that the community and the neighborhood is also doing that, I think that it serves the purpose of our NRSP standards here.
Okay, let me hear from the planning department, maybe. Thank you, Deborah.
Yeah.
Morgan? How are you, Morgan?
Good evening, Morgan Slater for the planning department.
Morgan, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So for a little background, the residence was constructed in 1964 and it's pre-existing to modern zoning regulations. NRSP jurisdiction for this property, because it depends on property size, is 100 feet from the bluff crest, and the required bluff crest setback is 75 feet. As it's been stated, the planning department has no objection to the reconstruction in place and kind of the bulkhead. The wire fence question, I think something that the board needs to consider is approving a structure on the seaward side of the bluff crest would be setting a precedent if the circumstances of this specific application aren't especially unique. So if there's some sort of uniqueness here, the board should explore that, but in any other case, it would probably be setting a precedent. And as far as, neighboring parcels having fences on the bluff crest, it's probable that those were never issued relief for those fences. The outdoor shower on the north side of the residence is depicted on the 2010 CO, and then the second outdoor shower is about 54 feet from the bluff crest. By my measurements, the northern shower is 76 feet, so it just meets that required 75-foot setback. And then, so the new shower does not meet that setback. And the board should heavily consider if the additional shower meets the variance standard, since there is already a conforming shower on the property that meets the required bluff setback. And as it's been stated already, the planning department does not have an objection to the minor structures, like the fencing and gates on the north and south side of the residence. Those meet the bluff crest setbacks. They just need an NRSP, as does the slate pathways. The AC units do need a variance, but those are, expected structures associated with residential development and don't have any anticipated substantial environmental impacts. I can answer any questions the board has.
Okay.
Yes, no, the question is the black pipe.
Yes. So
Is there anything that you know that restricts it, allows it?
it's a bit of a gray area, I think, with the code, because things like hose spigots don't typically require like a building permit or anything to be installed. It doesn't, based on Member Savarise's photos, it doesn't seem like any trenching was needed for that pipe. It kind of just runs alongside the staircase. So the planning department doesn't really have any objections to it. If it's not being used anymore, then it probably should be removed, just so it doesn't become debris or anything. But again, that's kind of up to the applicant to speak to.
Thank you.
Thank you, Morgan.
Anybody in the public who would like to address this application? Matt, is there anybody online?
You have 0 callers. Thank you.
Thank you. Can we have a motion?
I just have one more question for Ms. Shoren.
What's that?
I just have one more question for Ms. Shoren on the shower, if I may. Was there, I know what you're saying about like going to the kitchen and your towel while, people are hanging out, but was there an option I don't know, obviously on the internal floor plan, on the south side of the house that would have been in a location for better access to the house, but further back from the setback?
No, I don't believe so. I think that it comes off the master bedroom there. So I think that that's where the entry point is. That's how it was explained to me. I haven't not been on the interior of the house, but again, as you could see, and as we just heard, the piping for this outdoor shower was in existence and it wouldn't theoretically require a building permit. So it did grow in nature, but the use of it has been used as like rinsing off, and that's just what they preferred to use. So they've been using it since they owned the property and then built it out to be more enjoyable and private. So the use and intensity of it really hasn't changed at all. The cedar siding and then the slate below is the addition that technically would qualify it as a structure, but it's been there without incident and without any detriment to the neighborhood as far as I am aware. So I think that it does again satisfy the criteria for approval, and no one's looking to intensify the use by having a bunch of outdoor showers. So certainly to satisfy the board, they don't need the other one.
The Beagle gets its own shower.
Yeah.
Do you have a
Thank you.
motion?
We're ready? Okay. In the matter of the application of John Zuccotti, 91 Water's Edge in Springs, Suffolk County Tax Map Number 300-83-7-8, I make a motion that we close the public hearing and record.
What, aren't we leaving the record open for posting?
Why? I'm sorry.
Why?
Posting.
For the posting?
Oh, yeah, okay.
That's correct.
Let's correct that. Make a motion that we leave the record, close the public hearing, but leave the record open to post the property for 10 additional days. For neighbor comment. Anybody
Second.
want a second?
Second.
Concur. It'll be
Concur.
posted tomorrow.
Thank you. That means you'll have to post it tomorrow.
Today.
It's
I think
posted today.
It's already got posted
Oh,
today.
it got posted, that's right.
Can I don't want to further complicate this, but just because of this like long discussion, will you guys do us a favor and go back to that poster and just write the date that the hearing record is left open to, so that if somebody does drive by and sees it, because right now it just indicates that the hearing is tonight. If you drive
True.
by, you believe it's already passed.
Yeah.
So just throw some extra information in there so that
And
we.
Keith, by the way, Keith, for the future, the code requires them to be on their own, like, structure type of thing. So oftentimes people walk up to telephone poles and can rip them off. So,
No, but again, what day do you keep this? I will have the date modified.
What's 10 days?
Well, 10 days from now, it's the
It's
24th.
the 24th, Friday, the 24th.
Take care of tomorrow morning.
Thank you
Thank
so
you.
much.
Thank you.
And they could submit it by email to the Secretary of the Zoning Board, stating that for the public, so everybody who's watching knows how to submit any comments.
all right,
Okay,
thank you.
good night.
All right, next we have Mary Elena and Dominic Marinelli at 257 Westlake Drive in Montauk, Suffolk, tax map number 300-12-3-23. The size and location is 39,978.48 square feet. At 257 Westlake Drive, Montauk Beach Development Corps, Subdivision 7, central portion of Westlake Residential Section Block 163, lots 3 and 4 in Montauk. The description is to remove 2 sheds, hot tub, gravel area, 1,125 square feet of patio, and existing fencing to allow approximately 1,740 square feet or existing patio with pavers, walkway, outdoor kitchen on patio and outdoor shower to remain, and to construct a new approximately 532 square foot swimming pool and spa pool fencing, 2 190 square foot sheds, pool houses without plumbing, with approximately 695 square foot of roof overhang and approximately 659 square foot of swimming pool patio, relocated driveway, relocated propane tank and upgraded sanitary system, approximately 5,550 square foot revegetation on a parcel of land within setbacks and jurisdiction of freshwater wetlands. The relief sought is a natural resources special permit pursuant to 255-420 of the East Hampton Town Code. 3 variances are required for this application. Variances of approximately 77 feet, 74 feet, and 44 feet are required from 255-430 of the Town Code to allow the proposed fencing to be located 23 feet, walkways 26 feet, an existing patio with outdoor kitchen 66 feet from freshwater wetlands where 100-foot setbacks are required and any other relief necessary. Zoning district is B residence. Zone X flood zone is secret class is type 2. Council, do we have proper affidavit of service and posting?
Yes, I've reviewed the affidavit of service and posting. Everything appears to be in order, and the board has jurisdiction over this application.
Well, this was Ed's, but I went to the property too, so I'll do my best to cover it. Okay. All right, well, this was the post service and posting. It was properly posted, and you can see the house in the distance. No, this looks like he took a shot southbound on Westlake Drive. Next, and eastbound on Westlake Drive. That's the applicant's driveway on the left there. Next. Now, this is the front of the house, and I believe this is in the area where there was a culvert that was dug up and replaced by, I'm not sure if the applicant or the building department did it. I think that the highway department did it. But you'll see there are photos in the file about construction and all that. And next.
That's probably part of the same structure there?
Is it part of the culvert? Maybe that's where it used to be, or? And there was like a swale that I know when I saw it kind of dipped down. It's all grass now, but yeah, okay, go ahead. Okay, and this is to the north side of the applicant's property, I believe is where the reeds were. So again, well, let me say north, but sometimes I'm saying the wrong direction. It's toward the Gaffney Court side, so that would actually be, yeah, north, okay. Next. All right, this looks like it's on the south side of the house. You see a gate that will be going through I believe it's a septic there that's going to be removed. I think that relates to the septic that will be coming out. And then the gate, and behind the gate, I'm sure he went there next. Oh, no, he did the septic first. Okay, so next. Okay, now this is on the, I guess, east side, west side, east side of the gate, and going toward the back of the property. These are the 2 sheds that are being proposed to be removed as part of the project, as well as some of that gravel. Next. This is part of the, well, shot of the patio in the back, shooting from south toward northerly direction. You can see the hot tub that's proposed to be removed, and the 1,125 feet of patio that is proposed to come out. Then the applicant can explain which part of that it all is. That's the kitchen in the distance, so that looks like the part they want to keep. Anyway, next. That's a shot from the other direction, from the, I guess, westerly direction toward, looking at those 2 sheds again. And the gravel there. Another shot of the patio, some of which is coming out, and the hot tub that is going to be coming out. Next. And it's just shot, the property, as you can see on the survey, extends back pretty far. It is a lot of turf grass throughout the property entirely, and that is in the vicinity where the pool and spa proposed, and 2 pool houses and the pool equipment in that vicinity there, toward the left of that shrub. Well, maybe not to the left, but in that vicinity generally. Next. There's a shot with the next door neighbor, and I believe this is on the south side where the arborvitae are, if I recall correctly. Well, it says it on the site right there, arborvitae. And now that he's in the far corner of the northwestern part and just shooting back at the entire expanse across from there to all the structures that are in part of this application. Next. Some vegetation that's out there, I'm not really sure where. It was in the back, right? Yeah, it gets pretty dense because it does extend pretty far back on the property. I'm not sure I walked all the way back there. And, next. And now, yeah, he's in that vicinity, I guess, where all that shrubbery starts again, shooting back at the house. And another shot of that. And another shot of the vegetation beyond that. And now recognize the two lions that I did see that, and that extends back toward the rear of the property. Next. Another shot from there. And another one, I'm not sure, it seems like the same perspective to me from the side. And there's arborvitae there too. So this is on the portion of the property that's, I guess, a long Gaffney Court, which is a closed road. And another shot of some of the patio and the sheds and the driveway, not the driveway, but the gravel. And another shot of the front of the property. And yeah, that's the aerial, so that's it. Okay.
Thank you. Denise?
Good evening again, members of the board, Mr. Chairman and council. My name is Denise Shern. I'm an attorney with the Adam Miller Group at 2461 Main Street in Bridgehampton, here tonight on behalf of the applicant, the Marinelli family. We are here tonight seeking your approval for an application that I believe is best described as two components. The first is when our client purchased the property, one of the first things that he noticed was, if you look at the survey, the property slopes pretty steeply from back to front. The property is an acre, where it's surrounded largely by half-acre properties, and they were having a serious flooding issue. So one of the first things he tried to address.
Serious what issue?
I'm sorry, flooding issue.
Can you bring they were having a flood, but, so I'm struggling with, first of all, why they did all this work without a permit.
Okay,
Let's get past that, because, we can't justify it because they had a flooding issue. This is pretty egregious what they did. So I want to know, if maybe even who the contractor is, was he licensed in the town? This is egregious what they've done.
So that's what I'm trying to explain. I apologize. So the first issue that they tried to deal with was flooding in the area, a serious flooding issue. That's why the culvert was there in the first place. When they bought the property, there was a driveway on the northerly side of the property near the wetland that was asphalt, and that was creating a runoff problem too. So he went to the highway department and asked them if he could fill the culvert in, or not fill it in, fix the culvert so that it would work properly and actually take the runoff and lead it where it needs to go instead of continuing to settle at the bottom of this culvert. What was happening is the water wasn't making it up to the pipe, so it would just sit at the base and sort of rot and smell. And it also created a hazard for him and his family in terms of falling into it. And I know that may sound outrageous, but I just want to say that it happened to me once, and we were in a camper and we made a turn too tight and we went in a culvert that was 3 feet deep, and it was not a pleasant experience. So I understand the fear part of it, of having something that deep that's just situated in front of your property. This is not an excuse. I am not justifying doing any of this without an NRSP. What I'm doing is trying to explain why the actions were taken. When you look at the picture of the property, especially the front of the property, it was not evident to him that he would need a natural resources special permit to fix the culvert. And it wasn't evident to him that he would need a natural resources special permit to fix the driveway. But I'm not here asking for you to feel bad or feel any sympathy or empathy. This is just a factual explanation of what happened. So with regard to the flooding that was on the property, one of the things that he did was install a linear drain on the patio. The patio is the only outdoor living space that they have right now on the property. That is proposed to be reduced in size by 1,250 square feet. When we were looking at the pictures, the area of the patio that's going to be removed is the area closest to the larger wetland off of Gaffney Court. And as was previously mentioned, Gaffney is a 50-foot wide, unopened, unimproved roadway that essentially is a wetland. A wetland that needs a little bit of help. It's not the most pristine wetland, but our goal with our client was to have him remediate this property to the greatest degree possible in order to protect that wetland. So part of the application is revegetating the property. The property's pre-existing non-conforming overcleared for the district that it's in. So we're proposing to revegetate, I believe, over 5,000 square feet, correct? I'm sorry, Katie Osiki is with me here tonight. She can speak to the planting plan if you would like more details on that. But it is, I hope you have the packet that we submitted. It is one of the exhibits in the packet, just so you can see how much vegetation is being added. With respect to the request that he's making tonight, those structures don't need variances. They need a natural resources special permit. So he's requesting a swimming pool and 2 accessory structures. They're labeled pool houses, but they're dry. They don't have plumbing. So actually they're just accessory structures, 2 accessory structures next to a swimming pool. So that part of the application, as I said, doesn't require variances. There's a dry well and a conforming location for the swimming pool. There have been dry wells installed, and there will be dry wells installed, in connection with the existing patio to control runoff for that. The gutters and leaders on the property have all been connected with the exception of one that will be remediated and is on order right now. The neighborhood, in terms of character of the neighborhood, we surveyed the area. Katie found about 20 pools in the immediate vicinity within about 450 yards of the property. So definitely an accessory structure that you see quite often on Westlake Drive, not something that would be unusual in the area. The one important aspect of the application is that the asphalt driveway that was on the north of the property is being moved to the south of the property, being reduced in size from 3,000 square feet to 1,400 square feet, and will have an IA septic system underneath it. So instead of taking up more real estate with septic and a driveway. We're going to do it all at once, and we'll use that quartz gravel, so it'll be nice and permeable there. The reason for the septic not being in the backyard is that the house, which is very modest in size for an acre property, it's a one-story house. I know it does say 2 stories on part of it, but that's actually a basement. It's below grade. So it is a one-story house. And excuse me, the proposal, of course, is not to increase the size of the house at all, but to keep it modest. And that's the way the client wants the property. We're not here seeking to overdevelop the property to take advantage of this application process or to seek anything that the board has not granted in the past. We have taken steps to mitigate everything that we're asking for. The NRSP, the variances, the 3 variances that we need. One is for the existing pool fence, which is at the moment running through the wetland. That's going to come out, and it will follow the edge of clearing. I know that was a topic at your last hearing. Our fence will follow the edge of the clearing so that we don't, so that no one mows the areas that are not supposed to be mowed. The second variance is for the walkways just around the northerly side of the property. Essentially, this is just to get around the house, so very minimal. And finally, the third variance is to keep the other half of the patio that does have, as the member mentioned, the kitchen components on it. So that will give them a little outdoor living space, a swimming pool, 2 accessory structures, a driveway that's much better for the environment, and an IA system that we all know the benefits of the IA system. This property does have an upgraded septic system from approximately 6 years ago, so he would not have to upgrade the septic system, but our request to him was to please do so, especially in light of these events having taken place without approval in the first place.
So you're proposing to remove 1,125 square feet of the patio. How was that, will that take it back to the last C of O date?
No, the patio and the kitchen were added without permits as well. So
how much, the outdoor kitchen and patio also?
Exactly.
It was done without permits?
Yes.
And what else? You added pavers?
Walking,
the 2 sheds.
The sheds, yes, that will be
property line
removed.
there.
Correct, yep.
And that paver area, is that being reduced?
The paver to the north, you mean?
Pavers where the sheds are now.
Oh, all of that stone will be removed, so that's going to be gone, and replaced with vegetation, grass.
More grass? A lot of grass there. A lot of living space to me, I think, grass. But,
of course.
okay, now also talk about the clearing. You said there's going to be.
Yes, that was my question.
I mean, how much of this is on the C of O before?
Oh, so right now, the clearing is in compliance with what we have on the C of O. So we're completely legal as far as clearing. We are proposing to revegetate so that it's less non-conforming.
Well, why can't you bring it back to conforming?
Complete conformity. Yeah.
I'll let Katie answer that.
I'm going to swear me in, right?
Swear.
Hi, Katie. Announce yourself.
Katie Osiki, East End Land Planning.
You swear firm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do. So the property has pre-existing clearing. I believe there's a letter from Mark Abramson. So it is conforming with regard to town code. Like, they're not violating anything right now. And we are proposing.
But one of the things we're going to be looking at is whether or not the mitigation adequately outweighs the egregious stuff they've done on this property. I mean, I'm looking at 2 what you call dry pool houses, and based on their record here, what they've done, how do we know they're going to be dry in perpetuity? After a C of O, I mean, if it looks like a duck, it's a duck, right? So it might act like a duck in the future.
With this
So
culvert.
how do we,
thing, we'll
it's
have
like,
ducks.
it's,
So in terms of the clearing number, is that something that I can discuss with the client, and maybe we will increase that number if he's okay with that? I mean, we are, where the buffer is, and where they're proposing is, the idea is to protect those wetlands even more. And trust me, I understand the driveway, the culvert, and that patio, it's a lot. And so we're trying to rectify the situation here and give as much as we can.
but it's more than that. It's the line of trees that go all the way around that property line into wetlands.
Yeah.
That's even more egregious. It's like, it's pretty brazen what they've done here.
And the culverting is more than brazen.
Except that culvert, I mean, so that driveway used to be asphalt. Granted, now it is larger, but it is stone, and we are proposing, I mean.
Okay, show us, yeah.
Yeah, so here's the existing driveway. It's quite large, right?
Mhm.
I mean, it's roughly 3,000 square feet. We're now proposing to move the driveway here, which is as far away from wetlands as possible.
And to
And
what
the upgraded
size?
sanitary system is going to go underneath there. So there will be, I don't actually think there's a covenant anymore, but it's still a variance with the health department to get that approved.
So the driveway will revert back to the original size of the driveway, but it'll be farther away from the wetland.
Correct, although it will also be pervious because the original one was asphalt.
So what will be the size of the driveway now?
It'll be, I think it's like roughly 1,400 square feet.
1,400.
Proposed. I can get you an exact number if you want on that, but, and there will also be, I mean, this was all cleared on the last CO. We're now offering quite a bit of vegetation in the front that's now protecting these wetlands or the culvert.
Okay, and that's the 5,550?
Yeah, so this is this hatched area. I know it's hard to read. It's almost easier to see on the re-veg, but yeah. So this is all the re-veg. On this clearing line right here, that's how it was and how it was CO'd, and it's been like that for quite some time. So, I mean, this is, in my mind, and even in Tyler's TAM, I mean, the re-veg that they're proposing is a lot of re-veg, and that's probably going to be the most beneficial to the wetlands themselves, as well as obviously the IA system.
You'll still be over,
Excuse me.
permitted clearing by about 4,000
And that's
square
something I
feet.
can certainly discuss with.
I think that should be discussed also, and you want to keep a lot of these things that went in without permits.
So this also shows a little bit clearer too. So the patio that comes out to here, this is all going to get cut back. This patio right here was put in after the CO, and it was kind of person who owns the house is a contractor, and he knew that he probably did need permits for that, but there was a flooding issue. And so he was going to come in. So the idea was to permit that. So the property goes from roughly 17 feet to 11, and the water does come down. There is, and I can have it added to the survey. I didn't want to keep giving you guys more information in terms of paperwork, but down here, it is that sunken patio in that photo with the hot tub on it. And there's a linear drain that does go out to 3 dry wells here that we can have plotted on the survey. So it is sized properly in terms of the runoff. And if you look at, I think you guys were there, it is all pitched to that linear drain. The gutters and the leaders go to there. I think there's one leader that doesn't go there, but that can easily be corrected.
And to do all that, and now you're also proposing to add a pool, a spa, 2 hot pool houses, we've said this already, I know, with overhangs and pool equipment. That's a lot.
It is, but it is also a large parcel, and the house itself is, I think it's roughly 1,700 square feet. It's not a huge house. There's not a lot of outdoor space in terms of hardscapes. I mean, this is his outdoor space.
Now, there's a common, okay.
I mean, the house was there. It's not like he's proposing this brand new build that is close to the wetlands.
Okay, and then the fence is going to be removed. That's off the property. That's on Gaffney Court now.
Yeah, so it
There's
comes off
fences-
here, and it's going to be proposed on the inside of the vegetation, so.
You're going to remove those arborvitae also over that property line there where the fence is?
that wasn't the plan to remove it. It was to keep and then to vegetate, mainly because I think it would disturb the wetlands more to remove.
You're
the-
vegetating all the way up to the arborvitae in the
They'd
back.
be on the inside, so they go roughly here. And so the vegetation would be on the inside of it.
You know, but they're off the property. You planted arborvitae off the property.
I personally not.
Not you, Katie, thank you.
You wouldn't do that.
No, I know you wouldn't do it. The applicant has, and
I mean, is that, I would actually
I think that was our question was environmentally, is it better for the environment to leave them?
Well, didn't they disturb it when they put them in?
No, but is it better to take them out now?
Well, now there's
That's the
a
question.
substantial root system, and I don't believe they are invasive. I know they are not native, but is it better to leave them and plant around it, or is it?
Well, maybe Tyler can.
Yeah, we'll ask him.
His opinion on that.
What's your proposal on? Let me take a look at it.
Now and the deer fencing is going to come out from beyond that.
Yeah, no.
And all the way from north to south also.
Yeah.
And it's all going to move in, if the pool were to be approved, it's all going to move in toward the pool,
big part
the
of it.
fencing.
Correct, yes. And it would be on the inside, so it would prevent any possible clearing.
Okay, so you're going to discuss additional clearing to bring it into compliance.
We did get a DEC permit. I think that came in after Tyler's TAM, so I just wanted to mention that too, so the board's
So
aware.
is it in your packet? I know you had a lot
It
of
is,
information.
yeah, it's, I think it's the last exhibit, actually.
I believe that was one of the conditions.
But pools are not a given in this area either.
Total, understood,
Natural
understood,
resource special permits.
understood. We do, we do think that the standards here are met and that the property being an acre in size and after the removal of roughly half of the patio will have a swimming pool and 2 accessory structures. It's not an overwhelming, it's not an overly ambitious plan for such a large property.
In your opinion?
We tried to keep it to the minimum of what the client wanted but keep the mitigation to the maximum so that we could demonstrate to the board our seriousness.
Stretch.
If the pool house is, I'm going back to the pool house. 'Cause
Okay. Yeah.
if the pool house is quote dry and it says it on there's an outdoor shower there. How is it a dry pool house?
Actually, we can remove.
You gotta
that.
get water line out there. It's gonna have a shut-off valve inside that thing. At least he's gonna be able to rough it out later.
So that
contracted.
outdoor shower, he's willing to remove that, and I can certainly have that updated. Already has an outdoor shower by the house.
What, can I?
Okay.
You done? I'm curious why the pool and the 2 pool houses are where they are. Maybe it was to maximize their distance from wetlands, but, there's sort of, like if the pool, and I'm not trying to redesign the project, right?
I'm not comfortable with this, like telling them where to put it.
No, I'm not telling,
I mean, we have a project before us and that's what we should be looking at. So you're just speaking for yourself with what you're going to say.
I mean, there's a
question.
If you, does the survey have a setback? I mean, there's really only one spot where it's 100 feet. And that's,
I guess sorry, Vice Chair, all I was trying to get at, if there was a way of
No,
a place to revegetate more on the property.
That's
Okay.
not, you can't speak for the rest of us.
I mean, if the pool was pushed back any further, there would be more clearing. So it meets the 100-foot setback for an NRSP. So that's why it was put there. And like I said, I'm happy to talk to.
It meets the setbacks for the NRSP.
Right? Yes, the pool. The
Pool is
accessory structure.
exactly 100.3.
It meets the code.
And if there's no builder's error, that happens.
True. I mean, it does have to be staked in the field.
That's true. That's a new law. That's a good idea.
All right, we should probably hear from the planning department.
Yes.
Let's hear.
Absolutely, yes.
I think so.
Tyler Borsak for the planning department.
Hey, Tyler, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So the subject property is located on the west side of Westlake Drive in Montauk. The application in front of the ZBA is in order to approve construction of a swimming pool, 2 pool houses or sheds, a roofed patio and associated structures to relocate the driveway, which required permits to remain, and upgrade the sanitary system. The project also requests to allow an existing patio and paver area with outdoor kitchen to remain, an existing outdoor shower, and to relocate fencing, which was constructed off the property and partially within wetlands to the north of the subject property. Several non-conforming and unpermitted structures are now proposed to be removed or remediated, including revegetating existing clearing, which extended off the property, and to remove 2 sheds on the southern property line, along with the surrounding gravel, which are non-conforming to side yard, lawn line setbacks, and pyramid requirements. The property is located in an area of Montauk with extensive wetland system to the north, which extends well beyond the boundaries of the subject parcel and are within jurisdiction of several surrounding properties. These wetlands are highly diverse with species of woody and herbaceous plants that constitute an integral part of the natural environment, and more specifically, the hydraulic system. In addition to diversifying the landscape, they play a significant and vital role in the storage of water, flood control, and the maintenance of water quality prior to recharge into Lake Montauk watershed and groundwater. This area of Montauk has poor soil drainage, and the improvements on the subject property and those surrounding these wetlands have impacts far beyond the borders of the parcel themselves, and will have cumulative impacts on the water quality of Lake Montauk over time. The subject property has gone through some significant alterations since the most recent certificate of occupancy, which was issued in 2018. And the planning department had serious objections with the work which had already taken place, in addition to the proposed project as a whole. A portion of the work that has taken place is now proposed to be removed or relocated in the most recent iteration of the application, along with mitigation that was not previously offered. The 2018 aerial images, which I can bring up if you'd like, but they're also in the existing conditions memo if you want to reference them. But the 2018 aerial images show the property undergoing significant construction around the residence, which then appears in the 2020 aerial images as being completed. This construction includes what is noticed in the public notice, including the patio paver gravel area to the west and south of the existing residence, the outdoor kitchen over the patio, the construction of 2 sheds along the property line, an outdoor shower, fencing, and significant clearing of the property, and some clearing and fencing extending into the unimproved right-of-way to the north. All this construction was done without benefit of proper permits in place, and it was completed by a new owner after a lot inspection had been completing identifying the wetlands on and off the property in 2017, and in which appear on the 2018 certificate of occupancy. It also appears that a portion of the wetland directly to the east of the parcel, identified in the 2017 lot inspection completed by the planning department, was filled, culverted, and the driveway expanded on and off the property. The applicants have submitted correspondence with the highway department, which states, quote, "To whom it may concern, the ditch at 257 Westlake Drive was replaced with a pipe and covered with soil. The highway department considers it an improvement to drainage and safety. The highway department was okay with this as is. Thank you, Kevin Cobb," end quote. It is unclear if the applicants received approval prior to filling in the wetlands within the road right-of-way, and also if the highway department has the ability to grant that permission, but the board should be aware of these changes which have occurred within recent history and which also speak to the improvements made on the property. The culverting of an open watercourse without any environmental review has serious impacts on both the flow rate and volume of water which flows into the surrounding wetlands. Culverting a watercourse prevents absorption of water by the surrounding soils, increases the flooding within wetlands that they flow into, and changes the ecology of those wetlands. The increase in rate and volume of water flowing through a culvert will exacerbate flooding both within the wetland boundaries and the surrounding areas, negatively impacting neighboring properties, both over the long term and the short term during rain events. The wetlands within jurisdiction of this parcel are extensive with poorly draining soils throughout the area. Changes to the hydrology have the potential to impact properties well beyond the boundaries of the subject parcel or those directly adjacent to it. At a minimum, the board should require an application be submitted to the New York State DEC and permits in place prior to the issuance of a building permit on this application, which it seems the applicants have already received. In addition to the filling and culverting of the wetland off of the property, the applicants expanded the existing driveway which traversed the wetlands on the northeast corner of the property. This increase in the driveway represents a significant increase in the semi-permeable surfaces through and within close proximity of a wetland. Since the original submission, the applicants have revised the plans proposing to eliminate the larger driveway that traverses the wetlands on the northeast side of the parcel and construct a new driveway on the southeast side outside of the boundaries of the wetland itself and in an area that is proposed to be disturbed for the installation of the upgraded sanitary system, as was discussed. In addition to the changes in the driveway, the applicants appear to have expanded the clearing compared to the 2018 CO, as well as constructed several other structures. The largest of this construction is the approximately 4,000 square feet of patio, pavers, and gravel behind the existing residence, which also includes the outdoor kitchen and on the patio and a hot tub. After reviewing the planning department's analysis, the applicants are proposing to eliminate and reduce a significant portion of this improved area behind the residence. The applicants have proposed eliminating the 2 sheds, surrounding gravel area, hot tub, and 1,125 square feet of patio, which is closest to wetlands. This leaves approximately 1,740 square feet of patio and pavers and the outdoor kitchen on the patio. While the removal of a portion of the patio, gravel, and sheds is a significant reduction in improved surfaces within close proximity to wetlands, the remaining patio and paver area makes up an area almost as large as the existing residence itself and represents a significant increase in improved surfaces on the property. As shown with the proposal of a swimming pool, patio, pool house, and other structures, there are conforming locations available on the property for additional outdoor space without the need to construct impermeable surfaces requiring significant wetland setbacks. Similarly, the additional fencing and walkway to the north of the residence are well within the required setbacks, although they are fairly minor structures. At the time of the previous assessment of the project, the planning department had suggested a revegetation of the northern portion of the property and the fencing be relocated along the new clearing line, be included as mitigation, which the applicants are now proposing to include as mitigation. The application includes 5,550 square feet of revegetation of the northern portion of the property, which will act as an essential buffer to those wetlands, help reduce runoff, and limit pollution and sediments from entering into the wetland system. The revegetation helps to mitigate impacts from proposed structures and the existing structures in need of relief, if approved. In addition to increasing the buffer to wetlands, the proposed revegetation helps to reduce the pre-existing non-conforming clearing on the parcel. The property currently has a pre-existing clearing of 29,416 square feet, where 19,994 square feet is allowed. The proposed final limits of clearing would reduce that existing nonconformity to 23,866. The remainder of the application is for proposed structures which meet the required setbacks from wetlands and property lines. This includes the swimming pool, the spa, pool houses or sheds, and roof overhang with patio below. These structures are proposed in an area of the property which was already cleared prior to the most recent CO and are proposed to be mitigated in part with the revegetation proposal on the northern property line to help reduce the impacts of the proposed structures to wetlands. The board should consider the impacts of additional impermeable surfaces, considering the significant improvements that have already taken place on the property in recent years, and if the constraints of the property are in keeping with the existing and proposed improvements. Finally, the existing sanitary system is also located only 49 feet to wetlands to the east. The planning department had suggested that the board consider requiring an upgrade to the sanitary system in the most conforming location practical on the property. The applicants have now proposed a sanitary system upgrade in the same relative location as the existing sanitary, which would be a modern IA sanitary system located 36 feet from wetlands to the east. This results in a reduction of setbacks to wetlands, but a significant upgrade in the design from a single leaching ring with tank to a modern IA system with 6 leaching galleys, which includes a sand wicks system to clean sand below. Given that groundwater was found at a highest expected groundwater elevation of 7 feet and grade is at approximately 13 feet, the existing single leaching ring is very likely in groundwater currently. The applicants may want to discuss or the board inquire why alternative locations which meet better setbacks to wetlands could not be utilized and how the current system design was chosen. Any increase in setbacks for leaching structures to wetlands should be explored and solid reasoning established why the current design is necessary. The board should weigh the mitigation offered by the applicants along with what is being proposed. The entirety of the proposed improvements results in a total lot coverage of 6,855 square feet, nearly double the total lot coverage existing at the time of the most recent CO. With the change in the driveway, the removal of several unpermitted and non-conforming structures, the total lot coverage will actually be reduced from the current existing 8,571 square feet. The increase in total lot coverage since the last CO, though, is proposed to be mitigated with the inclusion of fairly significant revegetation, the sanitary upgrade, where one is not required. In addition to the 82% increase in total lot coverage, the lot coverage is also proposed to be increased by 30%. That is mostly from the proposed sheds or pool houses, if you want to call them that. This includes the elimination of the two non-conforming sheds along the southern property line, along with the proposed construction of the new sheds with roof overhangs. While the property has undergone egregious violations of environmental regulations on a recently purchased residence, including the culverting and filling of a wetland to the east, clearing to install fencing and ornamental vegetation into wetlands to the north, and the construction of extensive outdoor space and structures to the west of the house, the applicant does now appear to be taking steps to eliminate some of those violations. The question for the board is enough mitigation offered to offset the improvements proposed to remain within setbacks and be constructed within jurisdiction of wetlands in order for the project to meet the NRSP and variance standards? Other than that, I can answer any questions you might have.
Let's address the location of the septic system. It's probably located there, I would assume, because of the invert coming out of the house, the existing.
I would imagine.
Coming out of the house, right? So wouldn't you consider the relocation of the existing driveway to over the septic system as adequate remediation for location of the septic system?
Well, I mean, the best location for the sanitary system would likely be to the southwest of the residence. It's going to be uphill slightly, but that should at least be a discussion.
Well, I'm looking at just, yeah, okay, I get that.
It's clear, yeah, the driveway in that location, I think, is the best location to put a driveway. Absolutely. The previous driveway was a similar shape to what's there now, but smaller. They expanded that since 2018, or in 2018, it appears. But yeah, absolutely. The current proposed driveway is the best location available.
Okay, but it's still larger than the original one.
No,
I'd have to measure.
No, the 1,400?
Overall, he said the overall, with the relocation of the driveway, our total lot coverage is decreasing, right?
Total lot coverage is going up from the last CO. It's decreasing from what it is right now because of all the other improvements that are being removed. Yeah. I can pay on it.
So the septic could be put where? Like where the pool is proposed to go?
It's just almost going to be impossible, though.
There's also part of that, I mean, there was, in this packet, there was a cost. I mean, it's a tremendous cost. I think it's almost $200,000 to basically plumb the house, so it goes out the back. So the idea is, as mitigation, is the upgraded sanitary system in the most practical way in terms of cost.
So what's flashing on the screen, I can slow it down or if you'd like, that's 2024 and that's 2016. So that was just before and current conditions. If you'd like me to. I didn't realize how fast it would be. So I'll swipe it. So this would be 2016. Just before they purchased the property. 2018 is when they purchased it. And the 2018 aerials, you can see construction's going on, but you can see there's a small patio in the back of the house. The driveway is much smaller, as you can see once you swipe it away. So that's what you're looking at. Is prior, what was CO'd is essentially this, and this is what's here today.
So that 2016 image, even though just from the aerial it looks like there's more vegetation, it's still. That 2016 image represented 29,416 square feet of clearing?
Yes. It was lawn underneath trees, essentially, which is
the understory was clear and everything.
There's no habitat value for that.
And do you have a view of sort of what I asked? I mean, the arborvitae extending well beyond the property line, there was clearing that went along with it. I think I stuck my head in, it's like mulched. in there. What is your view? Is it more disturbing to
Yeah, I
take
haven't,
them
I
out
haven't
and?
thought about it. I would lean towards thinking that native vegetation would be better, but if the record's going to be left open, maybe I'll add something to the file, just discuss it internally. It's just not something I even considered up until tonight. But I would lean towards thinking that removing it and putting something native would be better. But I can understand the idea of not wanting to disturb it. It's not an invasive plant, not native. But it's not an invasive plant, so are you doing more harm? I'm not 100% certain.
Well, once they move the
Okay,
fence,
so
the
what
deer
are we
could
gonna
eat
do?
it.
They're not gonna be able to maintain it though. Because you can't maintain something off your property.
You gotta take
What are they gonna
irrigation
do?
out.
Yeah, it would just have to, it would go wild at that point.
Well, that may be all well and good because the deer, as soon as they move the wire fence that's in there, the deer will be happy to eat the arborvitae.
Remediation.
So true.
That's very good, Sharon.
Devegetation.
Believe me, they will.
I thought they don't eat everybody.
I'm struggling with the re-veg. Okay, the IA system is nice, but there's a whole bunch of stuff that's going on here that still disturbs me. The pool, proposing a pool here.
Could we leave the record open and I could discuss that with the client?
To bring it into conformity.
And regarding those trees, I mean, I think you guys were there. They're not small trees. I mean, so removing them they have a root system. I mean, I personally think that would cause a lot more harm, especially because if it was an invasive plant, I get it 100%, but.
You mean the ones that are off the property?
Yes, those ones.
Yes.
Well, some of them are on.
Well, some of them are on, yes.
Some of them are, yeah.
Quite a line all the way around.
But you can see how much is off there.
Yeah, and they wouldn't be maintained, like you said. I mean, that's, the fence is going to be.
The fence is going to move.
Yes.
Okay.
Okay.
Well, actually, I was wondering
Any
if
other questions?
you weren't recommending
Denise, you good?
a scenic easement or anything.
Denise Schoen?
Just wanted to make, oh, I'm sorry.
Did you want to?
Yeah, I don't know. Is there, would a scenic
I don't
easement
think
be
there
better?
was much, I don't think we thought there was much value in including a scenic easement. It wouldn't be very large.
Yeah,
I don't know what kind of value that would provide on this property at least.
And I'm sorry, Tyler, right up there. I just want to clarify what happened with the culverting and the fill. What are you, what are you recommending? Sorry, it was probably in here
Yeah, I
somewhere,
don't
but I
know
just
if
want to
there's
hear,
much
what are you
for the-
recommending happen there now?
I don't
to-
know if there's much for the board to do since it's off the property.
Yeah, it's off
It's off the property. It's not really in your jurisdiction at this point. It's in the town right of way. It's just something to note for
Like, did they actually
this.
have permission to do that?
Right.
The highway department.
Well, that's what I was wondering. Do you know,
I'm
Katie,
curious,
do you know
did
the
they
answer
actually
to that?
have permission?
I'm pretty sure that he had spoken to Terry, and it was just a conversation. And then they followed up because they wanted something in writing, and that's why I believe, do you know the date of that, Tyler? When that email was, it was kind of like, did they get approval? But he definitely spoke to the highway department. And if you were there was, it was like a 2-foot ditch, and it was unsafe. And there was, I believe it was concrete underneath the driveway, and it was set pretty high. So when the water basically pooled. So where it is right now, I think you guys were there yesterday, so it wasn't raining. But I was there with Sean Barron, and there's a letter in the record, and it was raining, and it was definitely working because you could hear the water and you could see the water. So there's photos in there, and I don't know what else the town would necessarily want
It's working for their property.
Which way was it
It's more
going?
of a concern for the surrounding
It's the same exact where it was. So that pipe went in the
not
same
even
exact
something-
spot.
So it was running from those wetlands to the north,
Like right underneath,
Down
and same
toward-
location.
eventually Lake Montauk.
I believe.
There's not
That data is at the bottom. of the
Yeah.
Yeah.
It's going to negative.
Yeah, so it was after they were asking.
Surrounding properties, but we can't do anything about that.
So in the pamphlet, there's photos of it.
9:30.
I'm
Yeah,
done.
so that's,
I'm good with this.
All right. Thank you.
And there is, I don't know if it matters, but Sean Barron did write a letter, kind of discussing his thoughts on if it's really affecting, how it's affecting it. And
Who wrote a letter?
Sean Barron.
I don't know Sean.
Sean Barron's an he does,
Oh, okay.
He used to work with the town of Southampton doing like flagging of wetlands.
yeah, and
Now
he does test pits and stuff like that, right?
Okay, where are we?
Anything to add?
Public.
One last question. If it's possible for member Ed Bonin, if I'm pronouncing that right, what is it, Johan? I'm sorry, Johan, would he be able to watch the video and participate in the vote?
That's usually what we do.
Absolutely.
Thank you.
So we're leaving the record open?
Yes, please,
How
because we
long do you
want to
need?
talk about more revegetation, and are there any other issues you want us to talk to the client about? But
The pool.
we'll talk to him about the trees. We'll talk to him about the revegetation.
Well, there's also those, some small, like removing of the outdoor shower he was okay with, which.
So come back to us on that. How long do you need?
Want to address the pool?
4 weeks.
Yes, I mean, it's an NRSP, right?
And you'd want the engineer's plan as well, probably, so they all match, right?
Yeah.
Ideally.
And any alternatives for the
4 weeks?
swimming pool?
I'm sorry, Denise.
4 weeks, you said?
Alternatives for the swimming pool?
Oh, wait.
Any
Okay,
alternatives?
we're not done yet.
Locations?
There's really no, in terms of the 20-foot setback and meeting that 100-foot, unless they're pushing it and asking for a variance for it, which I'm sure that's something that you guys don't want.
And how is that going to be impacting the wetlands?
What do you mean?
The pool and the
I mean, it's
structure and the
100 feet away.
drainage?
There is a dry well for it.
Just one?
Proposed on the property, just one dry well right here. So it's going away from
Yeah.
the major wetland to the north. I honestly don't think that this pool is going to have any impact on that wetland at 100 feet away.
Yeah, and in terms of hardscape that's there, there's the letter from Ed Armas in there that, it's the calculations for drainage, it meets town code.
Okay.
You can certainly document that too. I don't know, I can.
You're asking for 4 weeks.
4 weeks.
Okay,
Yeah,
all right. Can we have a motion?
Okay, so that's 4 weeks is, give me a date. Okay.
June 11th?
11th, June.
Yeah.
Okay.
We have a meeting, right? It's a work session, I think, but I think we have it.
So for the application of Marielina and Dominic Marinelli at 257 Westlake Drive in Montauk, tax map 300-012-03-23, I make a motion to close the public hearing and leave the written record open until June 11th for additional submissions and hopefully more revegetation and other things.
Before you
Second.
vote on that, I just want to make an announcement that you have 0 calls on the line. Thank you.
Thank you. Thank you. We forgot about the public.
Well, clear here. Good to know. Good to know.
All right, so we had a second? Do we have a second?
Second.
Second.
All right.
Thank you. Thank you very much. Have a good night.
All right, let's move along. We have an administrative application this evening at 60 South Forest Street, LLC, 60 South Forest, Montauk, subtax map number 300-28-8-32.1. And that's to demolish the existing residence and construct a 3,270 square foot two-story residence with a 550 square foot attached garage, 490 square foot of decking and porches, 400 square foot of terrace, 600 square foot of detached garage, 448 square foot of swimming pool, 200 square foot of pool patio, 196 square feet of pool house, and an IA sanitary system on a property containing freshwater wetlands.
Okay, this was on 2 weeks ago, and I can't remember why it got pushed off. But it's so they're demolishing a roughly 1,872 square foot residence, which is located 34 feet from the edge of wetlands. And they're proposing a 3,270 square foot two-story residence, which meets the 100-foot setback. The sanitary system is currently 83 feet from wetlands, and it will be 150 feet from away from wetlands. No change in density. It's a 4-bedroom house and will be a 4-bedroom house. The owner is also proposing to revegetate 4,643 square feet, and will also include a 23,090 square foot scenic easement, which is roughly half the property. The pool is, I think, 360 square feet. There's a letter of support from the neighbor to the north. What other information do I have? Morgan also included an aerial of the neighborhood with some GFA numbers in case you're interested in those, to see what else has been done in the area.
How big is this lot?
This is 40, 45, it looks like.
Lot area is 45,727 square feet total. That does not include, that includes the wetland area.
Oh, okay.
Sorry, excludes or includes?
Includes.
So what is it, what is the lot area?
Excluding, it's 36,501.
And can you just run us through, I'm sorry.
No, could we see that aerial again?
Sure.
I mean, I live not far from this neighborhood, and I know how wet it is. There are pools, yes. But my concern here is with this going admin, is it's maximizing quite a bit on the house. I think it was an increase of, how much, 75% or more? Plus a pool.
Going from...
And I believe the clearing number on this is, what is the clearing?
Can you just run us through the coverages?
Yeah,
again, right?
I believe the clearing is maxing out at the absolute maximum allowed, which disturbs me.
Clearing is going from 16,142 to 19,125, or 19,125 is allowed. I don't know if that's before or after Let's see. Yeah, that's final clearing limits. Building coverage is going from 1,078 to 3,728, where 6,000 is allowed. Total coverage from 5,305 to 6,049. And GFA from 1872 to 3270, where 5250 is allowed, but that's not really super relevant for the NRSP part of it. And wetland setbacks, 34 feet to the decking, 46 for the residence as it is now, and 100 feet is proposed.
What are the parameters which you are bringing, would this makes you decide to bring this to us, administrator?
We felt that there wasn't much else to be gained through a public hearing. It'll be a 20-day notice period in case there's any neighbor comments, but we were very comfortable, and Morgan worked with the applicant on the re-veg, on the wetland buffer, which is 50 feet, scenic easement's 50 feet around it. The sanitary upgrade, well, the sanitary upgrade is required, but between the scenic easement and the re-veg, we were comfortable with the mitigation being offered as far, and didn't feel that there was much else to be gained from going to a public hearing, which is why we were comfortable with it going without a hearing.
Even though the clearing is going to be maximum when it's done. I don't know, I'm just not comfortable.
Can I?
Go ahead, you want to say?
Yeah, I think, so there are considerable environmental or benefits that you named, right? Like the scenic easement, the re-veg, better wetland, better setbacks. But at the end of the day, and again, I think the decision to go admin versus full public hearing, it's not about what we think, of the application. Like, is it a good not so, I don't want anything, again, to be construed as like, oh, I'm concerned or not in favor of it. But I do think the thing to be gained is that when we have a complete redevelopment of properties where there are some, important expansions, I think the benefit, there's always a benefit of the full review of the board and the full public hearing process for these full redevelopments. There's a transparency to it. And so that's why I'm uncomfortable proceeding admin only, notwithstanding your good advice, on full redevelopments.
So are there any variances requested?
No, it couldn't be.
So that's correct. So it's bringing a property into conformity.
Right.
And we're getting an environmental benefit.
And that would be nice for people to hear about too.
Right.
And I
And
just
it's an
wanted to
NRSP.
make sure, because
And it's
I was listening, but I want to make sure that we're not misunderstanding, because there still is going to be a notice requirement, right? There still is, it's 20 days, right? So if, and this is also sort of clarifying for my own edification, because we've been reading the section of the code and it needs a little bit of work. But if we notice it and anybody, and there are any neighbor or otherwise comments brought in, then it does potentially get kicked to a hearing,
Yeah.
right?
It
Okay.
has to be a substantial environmental concern, but yes.
Okay.
And isn't it posted 20?
20 days.
20 days.
Yeah.
That's what I thought.
But I've seen public make comment to ask for a public hearing for admin-only postings, and those, I've seen them ignored. So
Depending on what the comment is.
they were related to,
Or whatever,
yeah, I mean,
it's history.
yeah, so.
Okay, I'll wait in. I think I would support it going to administrative. I think the environmental benefits outweigh the increase. Go ahead, anybody
I think
else?
there are a lot of positive things about it, but it's just the size overall.
But the size is
And then
conforming.
Yeah.
But it needs an NRSP. I mean, we just had 22 Shore Road. I mean, you know, that was an NRSP too. But anyway, you have a lot that are developments that are NRSP only, I call it that.
Again, for me, it's not about whether this is a good application or not a good application. I understand the benefits relative to size. It's just that it is a full redevelopment, and I think that warrants a public hearing.
I'm concerned about this area with the size of structure going up that much and then adding in pool too. I'm not saying it's a bad application.
But you're saying that you're denying the admin. It's okay. I mean, we gotta
I'd be
say
more
it. So
comfortable with the hearing.
Right.
here's what it is.
Yeah, and Tyler, to remind you, the reason why we're here again was because last time we discussed it, I think even myself included, misstated that I did not think that you needed unanimous board approval for it to go admin. It originally was raised by email from the applicant's agent when it was noticed that we had a 4-member board, but that is sort of irrelevant now because it is buried in 255-884 down here somewhere under J, paragraph J, 4. It does say, it says in some type of way that it needs to be unanimous. So this does not carry because we don't have unanimous vote. So I want to clarify, I was incorrect about that at the last meeting.
So we should have a motion to deny the
Going administrative, yeah.
Yeah, we do deny the public use. For the application of 60 South Forest Street LLC, 60 South Forest Street in Montauk, tax map 300-28-32.1, make a motion to deny the administrative application. If they put it to a hearing.
Good night, Katie.
Second.
Concur.
Okay.
Okay, next we go into post-hearing decisions. We have Peter Santoro at 163 Atlantic Avenue in Amagansett, Suffolk, tax map number 300-172-11-17. Size and location is 13,125 square feet at 163 Atlantic Avenue, Amagansett. The description is to construct a 240 square foot swimming pool with associated drywall and pool fencing on a parcel of land within jurisdiction of freshwater wetlands and natural resources special permit pursuant to 255-420 of the East Town Code. East Hampton Town Code is a relief sought. The zoning district is A residence AE BFE, base flood elevation 10, secret class is type 2. This would be in Amagansett, so we'll start off with Member Mary.
Thank you. And before I get into the post-hearing decision, I've raised this to council. I just need to make a quick statement about my participation in this hearing. Nothing had come up of concern from the applicant or the agent during the hearing, but a week after the hearing, the applicant's agent actually made a very public statement that I should have indicated that I had, quote, written a letter of critique about the application prior to my time on the board, that I'd previously taken an opinion of the application before I was on the board. So I just want to address that. And he said that he was concerned that I had not made some sort of statement, that I was not conflicted. So I want to allay any concerns. First, I never wrote or submitted any critique of the application or formed or previous application. There was an email I had written back in June of 2023, only to the board secretary, and it only did two things. It pointed out a very material typo in the agenda description, and it referred, unrelated to the application, to a real estate listing about it. And I didn't submit them or ask them to be into the record. So nonetheless, and that email for transparency was put into the record for this hearing, and I was never told to reference that was the transparency. But nonetheless, for full transparency, I do want to say, I want to say that any lingering concerns the applicant or their agent might have as to my objectivity, I want to state plainly, I have no conflict, harbored no pre-existing opinion that would compromise my ability to make a fair assessment or make this decision relative to the code and under the law as a member of the board. So I just wanted to be really clear on that so it's not hanging out there. Okay. Turning to our post-hearing deliberation, the public hearing was held on February 27th, 2024. The application is seeking an NRSP from this board to permit construction of a 240 square foot pool positioned on pilings to extend the existing decking attached to the south side of the house to accommodate the pool, to retroactively cover the installation of AC condensers, and to construct, quote, pool enclosure fencing. The applicant was represented by attorney John Tarbett of Tarbett and Lester. Morgan Slater represented the planning department, and the TAM was dated 2/8/24. As I recollect, there are no members of the public who participated in person, dial-in, written submission to the record. The most recent survey we based our discussion on was from Saskis and is dated July 25th, 2023. There are important wetlands to the east of the eastern property line on what's believed to be trustee land. The pool and the decking do not require any area or wetland variance setback relief. With respect to the parcel itself, the lot area is 13,125 square feet, which is 67% substandard to the A zone minimum. The parcel, I think it's important to remind ourselves, that is contiguous to the Atlantic Double Dunes Reserve. It's in a significant coastal fish and wildlife habitat, and it's located in an East Hampton scenic area of statewide significance, where alteration of natural terrain and dune habitat for residential development are to be discouraged. Existing clearing on the parcel, we discussed clearing a lot during the hearing, is 10,160 square feet. That's just 7.6 below max allowable clearing. Building coverage is also, will be 7.6 below max. Total coverage, which expands modestly, will be 37.3%, which is material below the 50% max. The sanitary system on the property is noted to be a conventional one rather than a low nitrogen IA system. Prior to the hearing being opened, it was noted that the applicant had not sent proper notice to the East Hampton Town trustees, which are indicated on the survey and noted in the application as an adjoining neighbor. Chris, is it Carrillo? I couldn't find the spelling. Thank you. Chris Carrillo, who's counsel for the trustees, objected to the opening of the hearing in light of notice requirements per 255-923, but the majority of the board agreed to open the hearing and proceed, but also leave the record open for 30 days after the hearing until March 26 to take in comments from the trustees that A, would be with respect to the application itself, and B, that would explain or make a trustee decision to either approve or deny the applicant's request to gain access for construction via the trustee access road that runs along the southern boundary of the parcel. In addition to the trustee input, we also left the record open to receive a construction protocol as well as a revegetation plan. With respect to these additional elements for which we left the record open, I didn't see it, and I confirmed it didn't come, that we did not receive into the record any comments or input from the town trustees. Prior to the March 26th close of the record, we received a one-page document from the applicant's agent dated March 25th, titled, quote, construction protocol and revegetation plan, and that indicated two elements. First, a 565 square foot added area to the northeast of the residence to be re-vegged with beach grass and bayberry, and also noting the existing vegetated area along the eastern side of the parcel will be supplemented, quote unquote, with bayberry. And second, this one pager showed an indication that a, quote, dirt ramp would be placed from their own driveway up over the northwest corner of the retaining wall. Except for noting that access ramp, I want to hear what my fellow board members will have to say. I did not see any actual documentation of details of construction protocol submitted into the record. With respect to the fencing element of the application, I'll address that separately at the end. But regarding the other three elements of the application, the pool, the added decking, and the AC units, after full review, I do not think they themselves will cause material incremental environmental impact or degradation. I note again that they meet wetland setbacks, although they are still within 150 foot area of jurisdiction. I won't read through the full standards of the NRSP per 255-551, but with respect to D, I do not see the establishment of these new three structural elements of the application as, quote, diminishing in size, polluting or degrading or placing in peril natural resources, natural features or systems. I do see the pool and additional decking as, you know, somewhat modest in scope and scale and are, like the rest of the house, raised on piling. So I don't see them creating an undue disturbance to natural features. However, it's clear that the natural resources conditions relative to natural resources protection standards and purposes on this property are poor. The lot has been stripped almost completely of the duneland vegetation and habitat that is supposed to define this area. Moreover, the administrative NRSP granted May 19th, 2008 for the redevelopment of the property established two very clear conditions. Condition C stated, quote, all areas disturbed by construction activities shall be revegetated with beach grass or other vegetated species native to the area of East Hampton. And condition F said, quote, the establishment of turf lawn, sod, or ornamental vegetation shall be prohibited. Neither of those conditions seem to have been complied with. We also know per the existing memo in the public hearing file that the Suffolk County Department of Health Services approval dated May 18th, 2010 was based on an existing clearing of 7,462 square feet, but that has since increased by 36% to the 10,160 that was issued. Sorry, and there's a new NRSP that we are now being requested to grant. A property approaching max allowable clearing ratio does not necessarily appear to be compatible with natural resources protection standards. During the public hearing, the board had substantial discussion about the extent of the clearing on the property, the fairly expansive area of mowed lawn that has been established, as well as what appears to have been a thinning of vegetation in the buffer area. In addition, we all explored the difference between a 2008 vegetation sketch that was issued around the time of the administrative NRSP, and then another vegetation sketch or plan that was subsequently established in 2010. I appreciate the applicant agent's position that clearing on the property is below the maximum allowance per code, that fully cleared areas on the property are further than 50 feet from the wetlands, and that the most recent C of O was issued while the property is in its current condition. But within this new NRSP application, I do believe we should ensure that we see the overall natural resources conditions on the property do come closer to NRSP standards, and so approving the structures, I would suggest condition of that approval that we reestablish the two conditions, C and F, and the property be brought into compliance with those standards. I believe the areas of mowed grass lawn that were improperly established should be eliminated and vegetated with a mix of native grasses. And I do believe, if board members see it the same way, that clearing should be restored back towards the 7,462 square foot level. And I'm actually, because there's been problems maintaining the buffer, I'm also want to consider if that buffer area should actually be a conservation easement. All those things would bring this parcel closer to compliance with prior NRSP granting, but importantly, it will align it with the important conditions of the SAS and the significant coastal fish and wildlife habitat area. And I don't think that adding more natural vegetation will undermine reasonable use of the property. It will make it more compatible, as is required per NRSP, with 255-111B, which is protection of neighborhoods, 255-111E, preservation, and 255-111L. Just to wrap up here, with respect to a few other items, I still feel like we need a condition for a more fleshed out construction protocol. I'm not sure there's a dry well for the existing shower. I can't see it on the survey. And then finally, with respect to the pool enclosure fence, if you look at the survey, it seems to run right on or next to a good chunk of the retaining wall. And I know that, I don't know if it's on the outside or the inside, but I do know that code prohibits, it's not in our jurisdiction, but code prohibits putting, you get 4 feet fencing by right, but it has to be measured from grade. So I do want to just suggest that perhaps, depending on what that fencing is, needs to be referred to the ARB in their jurisdiction for approving fencing. So you only get 4 feet by right in the front yard. The side yards would be 6, right? So I just wanted to raise that. That's what I have.
Okay, thank you. Terry?
Okay. Yeah, I was struggling with the, well, bottom line is the pool itself, the proposed pool, we also came to the conclusion that it's not going to be an environmental detriment to anything. And in the town, they felt that it's relatively small and should have very little substantial impact. Bothered me is again, the submission with the protocol that came in for the dirt ramp to go over the retaining wall. And I don't know, I think I recall that the agent said that there would not be any clearing that would be done with this, but it disturbs me too that there was no real protocol submitted. Yet open to my fellow board members, I don't know with this particular property how extensive a protocol would be necessary.
Well, to the note of the protocol is, I had no problem with them constructing a ramp to a retaining wall. That's done in construction all the time. What I see here is I was trying to overlay the access road over, and it looks like you have the existing septic system kind of in the way.
Yeah, yeah.
So I think if anything, the protocol should have addressed that. So maybe we can condition that the protocol addressed properly. They address the protection of because that's, you can't have heavy machinery going over septic systems, so that's going to have to be protected somehow.
Yeah, Tyler had it up that it showed the ramp, and then there's like pathway, it goes right over the septic system, right?
You have the septic tank and on one side, the leaching fields on the other side, but it looks like that road kind of goes over the leaching fields. And they're trying to weave it, but they're not clear. We have to call attention to that because that's a potential problem. So I think, I don't know how to address that now other than to condition or to make a loud statement that they have to watch out for that. They have to protect that septic system.
Well, as I said, I have, I approved the pool and the decking, stairs, the AC unit. But that's my one concern. So if we could condition approval
Yeah,
for a
we have to.
building
It's a
permit
safety
on
issue.
a construction
yeah.
protocol, but who would review that construction protocol? Tyler?
No, I think we should have a clearer I would like to see, let's condition the protocol be overlaid on the septic plan as a condition of the permit. Right?
Update the survey.
On the survey. Yeah. It's got to be overlaid with the survey, with the septic system.
Okay, so it'll be a new survey
clear
too.
enough.
Okay. All right, I'm okay with that. And then the revegetation, I don't know, it'd be nice if they could go back to what was on the previous C of O, but it doesn't look like that's going to happen. But they were mowing an area also, right? They were mowing it. Can just get them to stop mowing?
With the lawn that exists.
It's a lawn.
He wouldn't mind
That's where they're
a
putting the pool.
demarcation of that area, didn't he? He said he wouldn't mind like.
He meant towards the back. He meant
Well,
back
they came
there.
back with this, the revegetation up here.
But they've created lawn.
I mean, he stated,
lawn.
he stated several times that he thought the concentration should be on, the west side of the property, but of a heavy wooded, I would agree with that, but.
I'm not saying it has to be wooded, but, or all of it. But, can't have lawn. Like, that was the last NRSP. And we've got a lot of lawn, could be grasses, could be native. There could be some woody, to sort of protect some of the runoff that comes off of the block.
No problem with that.
Yeah.
Yep. For you?
No, I'm actually not in agreement at all. Are
She's
you
not
done?
done yet.
No,
okay.
no, I'm done. I guess it's, I assume, well, it's part of the conditions that they would have to protect it for that anyway, right? So whenever we get that.
Can you say that a little louder? I just want to.
No, that they would have to protect where they're going.
Well, there would have to be a
do the
limiting fence too.
construction,
So they
a
have,
limiting fence and
so let's
everything,
condition a limiting fence and septic system overlay. 'Cause
Yeah.
I agree with that. Denise?
Well, I don't think enough mitigation was offered to meet the NRSP standards. And this was actually my big concern. Even during the hearing, I asked if they could come in compliance with the clearing limits shown in 2010. They did not seem receptive to that. I would have approved this if it had a more robust revegetation plan. My biggest concern is with additional mitigation could have offered more prevention to not have excessive disturbance to the surrounding duneland habitat during the construction. And it does also, with the survey indicating maxing out existing lot coverage, 2,625 square feet is permitted and proposed is 2,425. So I don't think that enough mitigation was offered for me to grant this, to think that it meets the conditions of 255-551, D, preservation of natural resources. And I also don't feel that they do, they kept saying the pool's over an area that has been lawn, so before zoning, so that really is their open space. So they want to say that they don't have any open space, but they actually do. This is just where they want to put the pool. So again, I've said this a million times on this very dais, and a pool is an amenity. It's not a must-have, and I do not believe this is in keeping with the standards of 255-551 and 255-540, so I will be denying this application.
Okay, so I look at it this way. I look at the fact that this has gone through 2 zoning boards. One, albeit the first one is an administrative. They went through a 2010 zoning board, and now we're back again. They're requesting a swimming pool I think that the swimming pool, wanting the swimming pool should require, should have us look at a mitigation that exceeds what the previous two boards, meets or exceeds. So I would agree with Denise in the sense that, we do have a 2010 requirement under the building code, even though this present C of Os, and there's been a few that have not, that have been approved with the 2008 clearing. I think it's appropriate to seek out further mitigation because of this pool. So I would almost condition it on that they do meet with the pool, that they do meet the 2010 clearing
limit.
Right.
That's
So
a whole other.
We can do that, yeah.
Can we do that, Jameson?
I think we've done that in the past,
I
not often.
I think there's a nexus
did
for it.
bring it up during the hearing, so there is a nexus to discussion and talking about that, because that one of my main reasons for not granting this is it's not enough of a rebate for me. Not enough of a mitigation to meet the NRSP standard. But if we could bring it back into compliance with the clearing limits shown.
And again, I wasn't, that night I did view the hearing and go through the record, but I didn't hear any reasoning why they didn't comply or why the building department didn't require it. Or if the zoning board, subsequent zoning board application stipulates the clearing, shouldn't that be the law of the land? I mean, whether it's not, it was approved or not. So I'm saying the addition of the pool, I think there is a nexus for requiring them to meet the 2010 clearing.
That's what, I mean,
And
for
I did
me,
bring it up during the public hearing, but I don't really remember getting a definitive response.
I remember the response. I don't want to like muddy the record by misstating something. I remember the response had something to do with
the 2008.
Something CO'd that after the fact that superseded.
That is true.
Timeline, but but I still think, given all of that, if this board wants to, condition their approval on a re-veg number that we have a number certain and it was raised at the hearing,
right?
You do still have the authority to do that, regardless of sort of how we got here.
Right.
You have to get what?
Regardless of sort of how we got here, how they got to this existing clearing.
Right, I see what you're saying.
So for me, I was basically saying I would only approve it with the condition to restore vegetation, bring the clearing back to that prior level, and then make sure that the two conditions of that last NRSP, the no lawn and the, what was the other one? Whatever I said in my comments, like those to me are conditions of approval. Otherwise, I think we're sort of saying the same thing that you're saying, right? There was not enough mitigation. So it's just how do we come at it?
That evening, so.
Okay. So I understand that it sounds like at least we have a majority that agrees the 2010 clearing limits need to be established as a condition of approval.
Can we see what that is on the property card, Tyler?
There's a 2010 CO in the file.
Well, there was a survey that showed the clearing in 2000. I think it's the 7,000.
CO, and it shows the clearing limits.
Doesn't it say something like clearing 7,400 something up there?
Mm-hmm. What does it say up there?
Yeah, 7462.
Mm-hmm.
Yeah.
So I think they should bring it back to that.
I would approve it then. If we're all in agreement, then I would approve the application.
Yeah.
But we'd have to go back to the clearing limits shown in the 2010, what we're looking at right now. And what's that number, Tyler? 7,000 what?
7462.
I like that number.
You what?
I like that number.
Okay.
All right, are we good, Council?
Are we good?
Yeah, only one question though.
Okay.
What about, I know, so I only heard from one member about the additional conditions of the original approval about no mow. Does everybody agree with that?
Yes. No mow, no, I mean, the same wording
So
that we put in.
back to that. Go back to that previous one. Where is the no mow zone? Oh,
Where they're putting the
oh, that's part of the 2010?
It's 2010 CO.
Let's make sure that we're looking at the.
Council, your question is regarding the no-mow zone pertaining to what?
Member Mearing said that she wanted that as a condition of this approval to reconfirm that condition of the original approval applies again today.
Right.
When you say original, what is,
Prior zoning board approval?
which one?
Well, that's what I'm asking. I want to make sure that the whole board is
Which one?
saying, yes, you want that as the condition of this approval.
Right, so it was the determination that's included in the, there's a determination from 2008 where the ZBA administrative NRSP approved the redevelopment and of the property and the construction of the house. Condition C, all areas that were disturbed by construction activities shall be revegetated with beach grass or other vegetated species native to the area of East Hampton. And then condition F, which is the one that we still use, quote, the establishment of turf, lawn, or sod or ornamental vegetation shall be prohibited. But there's lawn surrounding the whole house. So I would like those to be.
Well, your question is no lawn.
My question is there a consensus on the board that this language be included in the conditions of this application?
Did this come up during the public hearing?
I think there's discussion about it.
No,
we talked about the lawn and how clear, we did. We talked about it.
And there was a concern that we were
That's the
asking.
2008 or 2010? What does the 2010 say?
There's a 2010 ZBA application?
The administrative one,
decision.
Michael Cosgrove?
What's the conditions?
What was the decision for in 2010?
This one.
2010.
This was to demolish the existing residence and construct a new residence.
That's the one we just
I thought that was 2008.
I'm looking at the 2008 one. Let me find the
Version of that
2010.
file.
One second.
I thought the date of the administrative NRSP.
I'm looking at an administrative one for Michael Cosgrove. It's May 19th, 2008.
2008, yeah.
And
That was the
approval.
There was a 2010 memo that says, from the planning department, that said that re-veg had been inspected and found to comply.
That's now I'm remembering. Remember that was what the applicant's agent was describing as something that after the fact, a revegetation plan that showed, I think what's existing now was also approved by the town.
Oh.
Right? Is that what he said? And that's that's on the property card. It's coming from 2010.
So there was not a ZBA decision on 2010? Was my understanding.
No, there wasn't. It was 2008 was the determination.
I thought the presentation was, okay.
Yeah, this is I can read this if you want. This is March 3rd, 2010. The planning department has inspected the re-veg plan submitted by the applicant and found it to comply with G3B of the admin approval of
2008.
Yeah, I see that, yeah.
Just the one permit.
And is that re-veg plan attached?
It's this.
Right. I guess this is where the
by removing the existing turf grass and installing plugs of native grasses, including beach grass, switchgrass, blue stem, mixture of shrubs will also be included, area wood, flood bayberry, shrubs to be 3 to 5 gallons. Yeah, within the buffer area.
Why was he referring to additional revegetation on the retaining wall as not being enough? That didn't exist in 2008, it existed in 2010. I thought it was a discussion.
The CO shows
Top of the
here.
retaining wall.
That's right.
But he said it didn't make sense then.
Yeah, that's all, it didn't make sense. I mean, we had an application before us not that long ago that had a, block with fill on top, right? And it's been revegetated, meaningfully in that area.
Regardless, I would even approve the application if the lawn was gone and all breach grass, but.
Right. But no, the two conditions I was citing were in the 2008 memo. Like, it's sort of like a determination, but it was admin only, but it had all the conditions. And
Yeah, see, on this document related to that 2008, they have revegetation that happened in here. That's not there anymore.
it was removed.
Yeah.
So are we
And that's where
good,
it being
James?
reluctant
So
to
perhaps we
put
should-
revegetation in here.
Yeah, that's one Terry's looking at now.
Mm-hmm.
This is in the existing conditions memo.
Yeah.
So then I would even be comfortable saying it reverts back to 2008 conditions.
This says revised January 19th, 2010.
Yeah, they
That's what-
definitely
That's
have
where
clearing limits
2010
shown in
comes in.
2010.
That's what I'm confused about.
Yeah, this is the James Rhymes land design. It did say.
What is the
retain.
CO, I mean, in terms of
CO
clearing,
matches essentially this here. The CO shows vegetation all along the edge.
and the number of for
But-
vegetation is how much on that 2010?
That's the 74,
Yeah,
62 number.
that's what we
That's
can agree to.
74. Okay.
So, okay, can we say 74, it should comply with that re-veg?
Yes,
No,
yes.
and the conditions,
That one
no
right
lawn.
there.
I think the
No.
conditions still apply.
Yeah, I agree.
I mean, this is a sensitive habitat area, and
Okay with that.
I would agree with that.
Yeah, that's.
Now, I got it, no lawn and 7462
Yes,
from the 2010 CO.
from the, yes,
do we need a dry well for the shower?
that's, we're good.
Yeah, dry well for the shower would be appropriate.
I don't have the TAM in front of me, Tyler. Is there anything else that the board needs to talk about? So we
I
can do
think
it
we're
now.
good. I've really dissected this application.
It's a good thing.
Fencing, re-veg plan, reducing system for the swimming pool, structures 2 feet above groundwater. That's it.
So the board agrees with all of this?
Yes.
Okay.
Got it, okay, we're done. Got it. Thank you, Tyler.
Okay.
Okay.
For a motion?
Move on.
Do we need a motion?
No, we just made.
Oh, no, right, we don't. Sorry, never mind. Sorry.
We have other decisions. Tourmalet LLC at 250 Old Montauk Highway, Montauk, Suffolk, tax map number 300-87-3-4. It's a modification to a 2022 determination, and board members, I'm recused on this application.
Oh, I have a, oh, you know what the problem is here? I denied this application.
Well, it's still a modification. Let's hear what I would say, hear what the
Normally, you
And I-
right, or it was already
I
in
denied the whole
progress.
application.
I thought this has been going on forever, this one.
Well, since I've been on the board,
Oh, Platter Day, yeah.
This one, you're thinking about the one next door.
Yeah.
This one
okay.
has yet to do construction. The one next door, Plata is,
Platter Day,
yeah,
yeah.
they're doing
They're
construction.
finished.
Done.
Yeah.
Only took
This one, hopefully I do a good job. This one's Brian's. So I will attempt to give the best rendition of it I can. It's very minor changes though, overall. It consists of reconfiguring the floor area of the basement, the addition of a bedroom, bathroom, dumbwaiter, and the reconfiguration of storage area on the first floor, and the reconfiguration of terraces, butler, pantry, and barbecue area on the second story. The modification results in a 7 square foot reduction in gross floor area, 333 square foot increase in building coverage, and that's mostly because of a roofed area outside over like a patio, and an 885 square foot reduction in total coverage. The proposed modification does not appear to reduce the protection of the bluff face provided by the board's determination. It's really hard to show the work. I was looking at this today because I'm covering it. So this is what was approved. So there was this patio here, which on the updated plans you can see is removed. So they actually removed something slightly on the seaward face. Not a significant change. They made some minor changes to this area here. The sun terrace, minor changes. What is this? This is a bit of an easier view of the, I think, top floor, second floor, yeah. So again, there's a patio here that was approved. It's been removed. The sun terrace changes. There was a fire pit there. Again, minor changes to what's already there. There was a covered area in here that's been added, I believe. And then on the first floor, some changes to the bedrooms, where different structures are located, and the general layout change. Again, this was approved. This is what they're proposing on this side. Minor changes, no changes in setbacks. And in the basement, they removed a home theater and they made it mechanical equipment and storage and changed the layout a little bit. Again, very minor changes.
They had a bedroom down there. It says in his memo.
I think the bedroom was the first floor.
That's where they added it?
Yeah. Yeah, there's a new bedroom on the first floor compared to what was approved. So they had a bedroom down, one single bedroom down here. They changed it a little bit and added bedrooms up here. Yeah. Moved a few structures around. It made the gym smaller, but the footprint's the same.
Okay. Yeah, won't count the gym. But they left the chef's kitchen.
It's not an easy one to figure out. Ultimately, the footprint really hasn't really changed at all, and the impacts on the bluff really are no different than what they were when it was.
It's their first modification. Yeah,
as far as I'm aware.
Probably. Yeah. All right, I guess I'm okay with it.
I'm okay with it.
I'm going to dissent.
You're going to dissent?
Yeah, I kind of have to. I mean, I wasn't in favor of the whole project. We can wait for Ed.
That doesn't matter. Yeah, I guess we may have to then, because Roy's recused. And why you said?
Oh, Roy's recused. Oh, that, okay.
But we're going to table it.
I think we have to
We're going to
table
wait for
it.
Ed, because I'm going to
After all that, we're going to table it, okay.
All right, next we have Dents and Michael at 414 Old Montauk Highway, Montauk, Suffolk Tax Map number 300-22-1-3.1. That's a request to leave the record open for an additional week. Can I have a motion on that?
Yes. So the application of Michael Denson at 414 Old Montauk Highway in Montauk, tax map 300-22-1-3.1. I make a motion to leave the record open until May 21st.
Second.
concur.
I concur. Thank you. Draft minutes of April 30th, 2024.
To make a motion to approve the draft minutes from April 30th, 2024 for the East Hampton Town Zoning Board of Appeals.
Thank you. We can move on to resolutions. We have 3 Beach Plum LLC at 3 Beach Plum Court, Amagansett, Suffolk Tax Map number 300-1110-2-19.2.
I'm making a motion to approve.
Resolution.
That was a denial.
I'm sorry, that was, that was a denial
of a modification.
Of a
modification.
Denial of modification.
Didn't we ask for it to go to a public hearing?
Was this an admin?
No, it was a modification.
It was a modification, but wasn't this the one where
Yeah, I think we
the
said for
board
a
felt?
hearing. Deny the modification
Yes.
for hearing.
In the reason supporting the denial, just to refresh the board's recollection, if you don't have the draft in front of you, I put
Draft?
the board suggests that the applicant pursue a quote modification with a hearing, in addition to the other things that you said at the meeting.
Okay, I'm sorry, if there was a draft, I didn't see it.
Oh,
Okay,
I sent these a long time ago, you guys. I was up on it.
okay, sorry.
You want me?
During your week off.
So I'm making that resolution, yes?
So this is the resolution amending the determination. So this was the request for the modification, and the applicant's requested modification determination is denied. The reason supporting the denial, I'm sorry, because I didn't know you guys didn't have it in front of you. The modification request involves increasing square footage of a structure within a minimum side yard setback, and the board believes that a public hearing would be appropriate to give potentially affected neighbors an opportunity to participate. The board suggests that the applicant pursue a modification with the hearing. And at the time, the following members concur with the modification denial, because Ed wasn't here, right? So I just have the four of you as concurring.
He was away.
Yes, that was
Right.
2 weeks ago. Was it? Yeah.
Yes.
Yeah.
Okay,
So the motion would be just to approve the determination as written.
right. Okay, so in the matter of 3 Beach Plum LLC, 3 Beach Plum Court, I'm against it. Suffolk County Tax Map 300-110-2-19.2. I make a motion to accept the resolution as written.
You second that?
Concur.
Concur. Thank you. Next, we have Henry Drucker at 298 Further Lane, East Hampton, Suffolk Tax Map number 300-189-6-11.5, and that was a modification to relocate a tennis court, but within the allotted setbacks, so it didn't increase any variances. So with that, I make a motion to approve the resolution of Henry L. Drucker at 298 Further Lane, East Hampton, Suffolk Tax Map number 300-189-6-11.5 as written.
Second.
Concur?
Concur.
Thank you. Next is Todd St. John and Stella Bugby at 18 Shorewood Road, East Hampton, Suffolk Tax Map number 300-92-7-5. And that was a deck extension that went on, the board approved. That was also a unanimous approval of the board. So with that, I make a motion in the application of Todd St. John and Stella Bugby at 18 Shorewood Road, East Hampton, Suffolk Tax Map number 300-92-7-5 to approve the resolution as written.
Second.
Concur.
Concur.
And we're going to have to table Sanger again.
Oh, yeah, can we adjourn that?
And we're
Because-
not going into exec on it.
No, I was going to ask that the board go into executive session to discuss an issue with that determination as I drafted it. But I did want Ed to be a part of that discussion.
Okay.
So we are at the 62 days today, but I think it's important enough that we will request that the applicant, acknowledge waiving it if they will. If not, we're going to just risk it
We're just going
to get it right.
Oh.
And hopefully we will be able to have the discussion and adopt the determination by the next meeting.
Okay.
Thank you. Vice
Are
Chair.
we ready to? Okay.
Alone.
I know. I'd like to make a motion to adjourn the zoning board of appeals on Tuesday, May 14th.
Second. That's what
Oh, I forgot that part, the most important part.
Otherwise, we have
At
to stay till midnight.
10:26.
Second.
Concur.